I know there was an issue around corona and
Can you please mute your microphone, Mr. Mkwanazi, when we start and then finalize it?
I've got the microphone. Yes. What about it?
Can you mute your Zoom session? Just mute on the Zoom session.
Okay. I need to.
Yeah, can you continue speaking? Can you continue
Can
speaking?
I continue talking or should I mute?
Continue talking. When I just want to test the level of your sound from the side. Continue talking.
Okay, I can hear you.
Yes.
I can hear you.
We can hear you. Just continue talking, Mr. Mkwanazi.
Yes, I can hear you clearly.
Today you are going to be listening
yes.
to Transnet evidence. Good morning, Mr. Mkwanazi.
Yes, I can hear you.
Good morning, Mr. Mkwanazi.
But still continue trying to connect on your side because that could be a fallback position.
No, your position is perfect, Mr. Mkwanazi. Can you continue talking?
Yeah, I can hear you. But now there's going to be somebody else in the room. I need to remove my ear thing so that that person should hear as well.
No,
Let me take off my...
It's not actually a good idea because what happens, Mr. Mkwanazi, is you get feedback in that situation.
Oh.
Because the computer microphone then picks up them speaking, feeds it to your computer, and then your computer feeds it back to them through the speakers. So it's actually better to keep the headphones on if there's two people in a room.
Lee, I think you need to explain something here. Let me remove the...
Hello. So if there's two people in a room, you have to have headphones on one of the machines.
We're just going to use one machine in the room.
Okay, that's very, very much too loud at the moment from you guys.
Oh, is the volume too loud from us?
Yeah, it was better with the headphones.
And now?
Dr. O?
If you can, I can hear you, Ray.
Better?
Just suddenly, Dr. O?
Can you hear the hearings? Can you hear the hearings?
I can hear you. We can hear you clearly.
Dr. O and Lee, please listen quickly. The challenge is if you're using the laptop microphone and Mr. Mkwanazi is not using his headphones, we can hear every movement. If you paste the paper, we can hear that from the laptop.
Now we can't hear you. Yeah.
Please use the headphones.
Okay.
If there needs to be a legal representative on the session who needs to hear the session, they must use a separate device, like a cell phone.
Okay.
Also with headphones.
Also with headphones. Yeah, headphones.
Otherwise, the machines interfere with each other and it's too loud, and that will cause the session to be disturbing.
I've got my headphones now.
We'll wait for you again. You're too quiet now, Mr. Mkwanazi. Rev?
Reverend is gone to fetch the DCJ.
I can hear the sirens going past, so we need to get this.
Yes, I can continue speaking. I'm speaking from the microphone of the evidence leader. If you want us to do some sound checking, I'm available to do some sound checking.
Okay, so we can hear the evidence leader. Can we hear the judge's position, please?
You will hear the judge very soon.
Yeah, but we don't want to hear it when he's arriving because we don't want to have to do testing when the man arrives.
Good morning, Dr. O. This is Swelihle speaking from the judge's mic.
Okay, good. Mr. Mkwanazi, can you speak again, please, so we can confirm that we can hear you now?
Yeah, I'm on my headphone. Can you hear me?
Well, we can hear Mr. Mkwanazi now.
Okay.
A bit louder.
Dr. O, we can't hear Mr. Mkwanazi.
There's nothing I can do about that. He needs to turn the volume up his side if he's using headphones.
Oh, okay. Let me do that again. The volume.
That's better. Speak again, please, sir. It's a bit better. Can you put the speaker by your face like so?
What speaker? Meaning
There must be
the,
a lamp on the cable.
oh yes, I see that.
That's much better. Okay, now we can hear you.
Okay.
Yeah,
Good.
no, we can hear you clearly, Mr. Mkwanazi.
Oh, me? Yes, I will keep on.
Maybe just count. It's easiest
Yeah,
to
let
just
me
count.
count for you from 1, 3, 5, 7, 9, 10, 11, 1, 2, 3. Let me switch off my phone. Okay, power off. Yeah, it's off now. Okay, my phone is off as well, so at least I've got the writing pad here. You can still hear me, I take it.
Yes, we can hear you fine.
Okay.
We're live in 4 minutes, huh?
Okay, we'll be live in 4 minutes.
Yep.
Dong, just come and have a look at the files that they gave me. Yeah, I'm seeing information I'm not familiar to.
So it's bundle 1, 2, 3, 4A, 4B. Mr. Mkwanazi's affidavit is in 4A. You have a similar bundle there. 1, 2, 3, 1, 2, and 3 was evidence that was made.
Rev, I'm going to hand control to the witness unit in the hearings room. Okay.
Thank you so much, Dr. House. Mr. Mkwanazi, can you continue talking?
Ndonga, wait, I'm talking to them. You mean, can I hear you?
On the system as well, because I'm not
No,
muted.
I don't hear you. I hear you because you're next to me. They wanted me to mute. Wait, come help me mute. So that in case even
So then you know
how to mute.
Okay, so you
Oh,
just-
yes. Okay.
Hello, Lee? Lee, can you hear me? Lee, can you hear me?
I'm going to change.
I've unmuted. I can hear you.
Okay, Mr. Mkwanazi. I'm just checking.
Should I mute again?
No,
No, don't mute.
don't mute. I want to check something quickly.
Okay.
Is Lee with you connected to a different device? Or your counsel?
We are connected. Good morning. My name is Mafika Mkwanazi. I'm the attorney from Mkwanazi here.
Okay, that's fine. As long as we can hear you.
That's connected to our team, it's myself and my colleague, Kumo Diole, and of course, the witnesses.
Okay, no, we're just testing that. When the judge comes in, you have to place yourself again on record, Mr. Mkwanazi. Thank you so much.
Thank you very much.
Thank you.
the judge has just come in.
Good morning, Mr. Mybeck. Good morning, everybody.
Good morning, Chairperson.
Yes.
Good morning, Chair.
Good morning.
Good morning, Chair.
Good morning, Mr. Mkwanazi. Thank you
Good
for
morning, Chair.
thank you for coming back to the commission, even though virtually, but you are not testifying
Thank you,
for the
Chair.
first time. Yes.
Thank you, Chair.
Thank you. Okay, Mr. Mybeck.
Yes, thank you, Chairperson. As you know, our next witness is Mr. Mkwanazi. He's going to be giving evidence via Zoom.
Yes, just 1 second, Mr. Mybeck. Where is that other light that is usually there? I thought there would be two. I don't know, I see it's a little dark, but maybe I shouldn't be concerned about it. Yeah, well, the technicians, the people who deal with it know what I'm talking about. I think they'll attend to it. Okay, Mr. Mybeck.
Chairperson, as you know, Mr. Mkwanazi is going to give evidence by way of Zoom, by agreement with the parties and with your direction. Perhaps he could be sworn in as a witness, and then I'll take him to his affidavit, and that can then be admitted.
Oh, okay, all right.
I have been asked to inquire whether you're happy with the arrangements.
Well, I'm happy with the arrangement. I'm just realizing that you will be looking there. I'll be. I wonder whether it was not possible to have this somewhere there where we could both see him, but it's not a big deal.
We tried that. There was really organized chaos before you arrived.
Oh, is that so?
Chairperson, I think this is probably the best that we can
Okay,
do.
let's stick to this so long, yeah.
And so if I might just mention that I think there is an absence of lighting. The lighting has been moved to my left so that it doesn't shine directly in my face, so that I can look at the screen. So it might appear slightly darker to you.
Okay, no, that's fine, that's fine. Okay.
Good morning, Chair. Good morning, colleagues. Chair, I just want to take the opportunity to say a word from Vice President. My name is Mafika Mkwanazi. I am a director of Transnet Incorporated, and I am with Mr. Mafika Mkwanazi. And once again,
I'm sorry. I think the reception is quite poor. I can't hear the speaker. I can't even.
Is it better? Chairperson?
Yes.
Okay, sorry about it. I was saying that this management is also again. My name is from Transnet Incorporated, and I represent Mr. Mafika.
Oh yes, it's Mr. Mkwanazi, the lawyer.
Yes, sir.
Okay, yeah, I remember. Yes. No, thank you very much. I don't know what it is, but when you speak, it's not as clear as it ought to be. I mentioned that so that when next time there is a need for you to speak, hopefully whatever it is that may need to be attended to will have been attended to, yeah. I hope Mr. Mkwanazi will be clear when he speaks. Mr. Mkwanazi, can you hear me? Yes, okay, it looks like we can hear you. Okay, Mr. Mybeck?
Yes, thank you.
I'll administer the oath of affirmation first.
Mr. Mkwanazi, please stand up.
Okay, I'm standing. Lee is witnessing. Oh, I need to go back. Wait, I need to remove this chair.
Yeah, so.
Yeah.
Please, please state your full names for the record.
Mafika Mkwanazi.
Do you have any objections to taking the prescribed oath?
I do not have an objection.
Do you consider the oath to be binding on your conscience?
Yes.
Do you swear that the evidence will give will be the truth, the whole truth and nothing else but the truth? If so, please raise your right hand and say, "So help me God."
So help me God.
Thank you.
I see you took off your jacket, Mr. Mkwanazi. Is it too hot where you are?
I can put it on, Chair.
Yeah, I think put it on if you don't mind.
Okay. That's very much. Okay.
I was wondering whether you took your jacket off because it was already hot there, or whether it was in anticipation of heat. Okay, all right. Mr. Maibek.
Yes, thank you, Chairperson. Good morning, Mr. Mkwanazi.
Good morning, Advocate.
You would have been provided with a bundle of documents referred to as Bundle 4A.
Yes.
Could I please ask you to turn to page 1 in that bundle?
Okay. Is it written Exhibit BB18?
Yes, that is correct.
I'm sorry, Mr. Maibek. On the spine, the first writing should be Transnet Bundle 04A. Is that correct, Mr. Maibek?
Correct.
Yeah. And then below that it says Exhibit BB18. Have you got the correct one, Mr. Mkwanazi?
Yes, I've got the one, Exhibit BB18, and then on the second page, it's an index, BB18,
Yeah.
then...
No, it is the right
On
one.
the next page, it's a declaration.
Yeah, it is the right one.
So, Mr. Mkwanazi, during the course of your testimony, when I refer to page numbers, I'm referring to the black page numbers. Here on this page, page 3 on the left-hand side. Do you see that?
I see that.
I'd like just to start off by asking you to confirm, is this your declaration?
That is correct.
If you could then please turn to the end of your declaration at page 20.
Yes, I'm at page 20.
And do you confirm that you signed this declaration on the 31st of August this year?
I do confirm.
And then I would ask you to confirm, attached to your affidavit were a series of annexures. We have A, B, and C. C was the KPMG report. If you then turn all the way to page, right at the end of the flag, to page 21.412. Are you there?
Not yet. I'm at 21.412. Yes.
We received the annexures up to A, B, and C. We didn't receive D and E.
Yes, I see that.
All right. So you confirm that annexures A, B, and C were annexures to your affidavit?
I will confirm, yes.
All right. Thank you. Now, Mr. Mkwanazi, if you could go back then, please, to page 3.
Yes.
What I'm going to do is I'm going to lead you through your declaration. And I'm going to give you the opportunity of presenting the evidence that is set out here. And after that, I'll have a series of questions for you, and obviously the chairperson would ask questions whenever he wishes to. You follow the process?
Yes, I do.
Okay, let us start off then with your personal details at paragraph 1.
That is true.
Were you an executive director of Transnet from 1996 to 2001?
That is correct.
You're also a former group chief executive officer of Transnet, and you held that position from 2001 to 2003.
That is correct.
And then I suppose, importantly for present purposes, you say, I'm also the former chairman of the board of Transnet, having held that position for a period of 4 years from December 2010 to December 2014.
That is correct.
You say that you were furthermore the chairman of the Corporate Governance and Nomination Committee, as well as a member of the Acquisitions and Disposal Committee during your tenure on the board.
That is correct.
You then go on to say at paragraph 4.1 that you were asked to provide this declaration, essentially dealing with the decision to enter into a settlement with Mr. Gama and reinstate him. Is that correct?
That is correct.
And you were also asked to deal with the terms of that settlement agreement.
That is correct.
Perhaps I could ask you then to pick up at paragraph 4.2 and verbalize what's contained there about your meeting with Minister Gigaba.
Yes, I think paragraph 4.2 confirms that I was approached by Minister Gigaba to join the board of Transnet sometime in December for a period of 3 years. And also in that meeting with Mr. Gigaba, he indicated a few areas of concern. One of those was a lack of transformation, as there were very few senior positions held by African women. The other, he was under the impression that the procurement systems of Transnet was open to corruption by employees and other stakeholders. He emphasized that as the incoming chair of the board, this must be an area of focus. He also somehow was aware of problems in the procurement of suppliers and services for mega projects in Transnet. These would have included the Devon Harbour entrance widening, the Cape Town Container Terminal, the new multi-purpose pipeline, the Muha Container Terminal, the coal line expansion, the Aono expansion, and the appointment of global consultants for engineering, procurement, construction, and management, and other feasibilities, and one or the other study. He also was under the impression that the disciplinary matter at Transnet were racially biased, and that there was a condonation process at Transnet that was generally used to deal with deviations within Transnet.
I'll just ask you to confirm, when did you hold this meeting with Minister Gigaba?
Sometime in October. I don't recall the date.
In October
2010.
2010.
2010, yes.
All right, please carry on.
I'm sorry. Is there a possibility that you might be mistaken with regard to the month, and that the month might be November?
Sure, I thought it was October. It's a long time ago, but I really thought it was October.
The reason I'm raising that question is that in October 2010, Mr. Gigaba was not Minister of Public Enterprises as yet. It was still Ms. Barbara Hogan, and she was dropped from cabinet on the 31st of October 2010. That's the evidence she gave, and her and Mr. Gigaba's appointment was announced, would have been announced probably on the 31st of October or 1st of November. So he only became Minister of Public Enterprises from the 1st of November. So I'm wondering whether it might be October or whether it might be in November.
Chairman, your observation is correct, but my recollection, it was sometime in October.
Sometime in October.
And, yes, and I'm not sure if the minister has put in his own affidavit. Maybe I'm wrong.
Well, we have got an affidavit from him, but I don't think it says anything about any date of your meeting, but I may be mistaken. But of course, it is maybe possible that maybe if he had been informed already before the end of October, maybe confidentially, that he would be taking over, maybe he could start looking at matters that he thought they were urgent. I'm not sure. But anyway, your recollection is that it was in October.
That's my recollection.
Yes, okay, thank you.
Thank you, Chairperson. Mr. Mkwanazi, then could you deal with the next heading, please? Background to deviations in contracts at Transnet.
Yes, Advocate, unfortunately I have to read from this transcript. Transnet has always had a detailed procurement procedure manual. Even in 1996, there would have been a tender manual and tender board that gets amended from time to time. These guide the organization on how to procure goods and services from time to time. Our board, the December 2010, December 2014 board, also amended the procurement procedure manual in 2011. Transnet also has a delegation of authority frameworks that gets reviewed by a subcommittee and is approved by the Transnet board from time to time. This delegation of authority framework defines the powers of the board subcommittees, and executives, generally up to the group chief executive. Then the group chief executive officer has authority to sub-delegate to his or her executive committee. In these delegations of authority, there are financial limits and other limits for all executives, including the Transnet board. Some matters get elevated to the shareholder for approval following the guidelines in the shareholder compact. In these financial limits, executives can increase certain contract values by a defined percentage or not exceed contracts by a predetermined amount. There are financial limits on appointment of consultants and other service providers. Should these be exceeded during execution, the responsible executive must report to his or her manager so that the issue can be referred back to the Divisional or Transnet Acquisition Council or the Transnet Board if it was the original approval. In most cases, the Transnet internal audit gets involved to determine fruitless and wasteful expenditure. This is how deviations in contracts are identified. The structure that approves that contract must determine if the condonation is granted or not. The line manager of the offender must take disciplinary action if warranted. Can I continue?
Yes, please. So then, in the next part of your declaration,
Yes.
under heading 6, you deal with, as you put it, the history of deviations at Transnet, and that runs through pages 6, 7, 8, 9, 10, 11, 12. And then at 13, you deal with condemnations at Transnet Freight Rail. At 14, deviations in respect of mega projects. and then one goes all the way to 17 before you then deal with Mr. Gama. What is it?
That is correct.
What is it that you want to say about the history of deviations at Transnet?
I will not read the submission line by line, but in a nutshell, there was a strange, it's not strange, it's part of the PPM, by the way, which the procurement procedure manual, which does allow for certain deviations, but they need to be approved further up, and also it allows for condonations. So what I was trying to sketch here, and by the way, the things that I mentioned in my submission are events from 2005, 2006, 2007, 2008, and 2009. I indicate that there were many deviations, there were many condonations, and there's three that comes to mind because they were major. There's one on the appointment or the condonation of the VAE contract, which somehow became irregular because when the approval was done, I think it was done at 980 million. And by the time it reached my office as the acting group CEO for condonation, the amount was 1.778 million, which is 1.8 billion, roughly. Now, and funny enough, that particular contract implicated a lot of people in some irregular behavior. In that those people, various teams in TFR, in group, kept on trying to fix this problem, and they delayed. I don't know why it took so long for them to bring this thing up to the board for condonation. But eventually it came to the Transnet board through my office for condonation, and I then elevated the matter to the board. And on elevating it, I indicated that disciplinary action needs to be taken against, it was most probably plus or minus 10 to 12 executives who had been involved in, some of it was worrisome. It bordered on doing things without authority, etc., etc. So yes, it was brought to the board, and a condonation was given by the board. So that's a typical, but that's a big deviation, and that's why it needed board approval. Another one which comes to mind besides the VAE contract is the HMG contract, which the executives, it started as a floor contract. Then about a year and a half into a floor contract, they then changed it to an HMG contract. But the processes followed were flawed, and therefore it became an irregular contract. And in executing that contract, certain elements of that contract were implemented irregularly, and there's some element of fruitless and wasteful expenditure in that contract. It came from a division called Transnet Capital Project, and the CEO was Ms. Moira Moises. And of course, even this contract, the HMG, had to come through certain processes and be looked at, and a condonation sort of required. Although the project itself was far bigger, it's just the irregularity of it that required a condonation. And in that process, the group CEO, Brian Molife, was instructed to take these disciplinary actions against not only Ms. Moira Moses, but maybe 3 to 4 other executives within Transnet Capital Projects. Then another big one which needed, now these condonations are now done in 2011, and yet these contracts were signed maybe in 2005, 2006, and 2007. Another big one was an AWP, Arab Wali Passes. where for some reason they were also an engineering procurement, construction management service provider. The contract value increased from about 1.7 billion to over 3 billion. And again, the board, sometime in 2011, had to take a decision to condone and also specify that disciplinary action must be taken on those involved. Now, I just mentioned these three, but there were others. Not too many, because I'm focusing on the big ones. Small ones in the KPMG report are mentioned. I'm not sure how many in total there were, but yes, others' contribution was granted, others' contribution was not granted.
All right. Could I perhaps just take you back to the beginning at paragraph 6.1? You say, this is at page 6, on 22 December and in February 2011, 22 December 2010 and in February 2011, the Public Protector made certain allegations about Transnet procurement procedures and the Gama matter. The new board appointed this JV of KPMG and Konki to investigate a number of issues around the procurement at Transnet on the basis of the Public Protector allegations and Gama's appeal on the sanction of dismissal. The first report was done quickly on as the information was historical. It is that first report that was used by the board in its deliberations. A law firm, Norton Rose, was consulted by Transnet, and a different law firm, Weber Wenzel, was used by KPMG and Konki. The final report was completed in November 2011, as there was a lot of resistance from executives in cooperating with the KPMG and Konki team. Would you confirm that?
Yes, I'll confirm that, and maybe let me add something that is not clearly covered there. There were a few board meetings that happened in January, and I don't have minutes of those, etc. But already before the end of January, Transnet at the time had a funny environment where people were coming with allegations of this and the other. So yes, the matter that Nkonki covered, even though the report was published, the final report was published in November, the company knew already of some of these matters. And I'm also looking for that information because I did present some of that information to the board or a board subcommittee even before the end of January in terms of some of these. And finally, some of these are not even mentioned even in the KPMG report, but I'm aware of them because I then forwarded, typically there was one which I forwarded to the group chief executive of an irregular consulting contract by the then group general manager. And yes, I still don't have the list of all consulting contracts that were entered into by, I still don't have it today, but at the time I was forwarded with what looked like an irregular contract, and I handed it over to Mr. Brian Monife.
So, Mr. Mkwanazi, what you then do at 6.2 is you start listing the findings of the KPMG and Konki report, as you say, which was finalized in November 2011.
That's correct.
All right. And then over the page at 6.4, you deal with an internal audit report dated May 2011. Is that right?
Yes, that's correct.
And then I just wanted to make sure that I understand. I mean, it seems to me that by and large, then the contents of this 7 or 8 pages is really taken from the KPMG report. Is that fair enough?
100% correct. But having said that, there were reports. There were reports like there was a report published called by Transnet Internal Audit. It was called Transnet or TFR Procurement Irregularities. I think it was done in 2008. I had seen that report, but now when I asked for that report, it's not available. So the fact that I'm using a November KPMG final report, to me, really is the fact that then KPMG had to go back and dig deeper of the things that were known to have happened as early as 2005, 6, 7, 8, and 9.
All right. Then, Mr. Mkwanazi, just so that I confirm and understand your evidence, you say, look, there were smaller issues, but you've identified, and I suppose it's appropriate to look at the bigger issue. You've identified three main examples. It's the VAE contract, if I understand you correctly.
That's correct.
The HMG contract.
Yes.
And what was the third one?
I think it's the AWP, Alan Wali Person.
AWP contract.
That's correct.
I just ask you to confirm, as I understand your evidence, you say that condonation was granted in respect of all of those irregularities, but disciplinary action was then instituted against the managers involved.
Wait. Condonation was granted on condition that the managers involved would be disciplined.
Yes.
Yes. Now, when the HMG condonation was granted, Brian Mulite was instructed to discipline Ms. Moira Moses. And I'm not sure of the dynamics of those discussions, but Ms. Moira Moses immediately resigned.
All right. Well, just to summarize then, in relation to each of these three big contracts, VAE, HMG, and AWP, condonation was granted on condition, as you've put it, that disciplinary action be taken against the relevant managers.
Yes.
All right.
That is correct.
Could I take you, please, to page 10 of your affidavit? And let me direct your attention to paragraph 6.5, where you deal with the VAE contract. And then at paragraph 6.5.1, the second portion of it, you say the VAE contract of 960 million in 2006 was subsequently increased to 1.775 million, or billion actually. Condonation for contract extension and payments without a signed contract was only applied for in February 2011 and was granted by Mafika Mkwanazi in his capacity as acting GC CEO, subject to disciplinary action being taken against those responsible. Is that correct?
Yes.
So would
correct.
you would
let me, I might have elevated that one to the board. I don't recall that. Yeah.
But would you confirm then that condonation was applied for?
Yes, it was applied for.
All right. And then if you go to page 14 of your affidavit, paragraph 8.2 deals with HMG. That's the other big contract that you spoke of. Is that correct?
That is correct.
Where do you deal with AWP?
It's somewhere in the report. I'm not sure, but it is somewhere there.
Yes, but
I'll have to find it myself. Yeah, it is somewhere in there.
do you deal with it in your declaration?
Yes, it's actually in a board minute as well, where I think it was a June board meeting where now this condonation was elevated to the board, and the board did condone the expenditure on AWP. But let's come back to HMG, yes.
All right. I wanted then to take you to paragraph 9 and to focus then in on the disciplinary action taken against Mr. Gama. Is there anything else that you want to say in relation to deviations and condonation? Historical.
Not really. Let's go to then paragraph 9.
All right, thank you. So perhaps I could ask you to deal with this. Could you start with paragraph 9.1 and take the chairperson through your evidence in this regard?
Yes. Should I read it?
Well, it would be better if you verbalize it, but of course you're allowed to have regard to the text of the declaration.
Now, let me verbalize it. From the view of, by the way, even this verbalization, I think maybe comes from the KPMG report, which was trying to indicate that on similar matters like Gamma, the company was consistent in dealing with certain issues. But then again, on similar matters like Gamma, the company was not consistent in that there are other, now these matters are not identical, by the way, we need to understand that. Because if then you look into detail into what are these matters, they are not the same. They are not the same, yeah. In a nutshell, that's it. Now, in a nutshell as well, what I'm trying to indicate, and I'm not with certainty, is that had Gamma been given the opportunity to go through the condonation process, maybe the authority to condone might have come with a different sanctions. I don't know, maybe demotion, maybe dismissal, I really don't know. But there's that possibility that the authorizing individual would have come to a different conclusion. Same as we had asked as a board that those who were guilty of certain irregular and certain fruitless and wasteful expenditure contracts must be disciplined. I don't know the outcome of those disciplinary actions.
All right, well, let me take you to the text.
Yes.
You say at paragraph 9.2, I submit that with regard to the Gamma matter and a review of similar fact matters, the board was of the view that disciplinary action instituted for the committed irregularities appeared rather to be an exception rather than the rule. We further noted that the disciplinary process was not consistently applied to all transgressions, but rather a process of condonation is consistently applied with no disciplinary action being taken against offenders. These observations are in line with Mr. Gamma's view that, quote, he was doubtful that other employees who had acted in a way similar to that way he had been charged for tender irregularities and that there was a selective application of charges. You say then Gamma was not afforded the opportunity for condonement in his matter based on the view that the transgressions were of such a serious nature that they warranted disciplinary action. However, evidence also suggests that other senior employees had, in certain instances, not complied with the necessary procurement procedures, yet none of them were subjected to any disciplinary procedures, as Mr. Gamma was. That's what you state. And then in two perhaps important passages that I might ask you a number of questions about, you say, I personally fully agree with the disciplinary process and findings of the then Transnet board. The only difficulty I have is that there was this common process in the Transnet systems called condonation. Based on the context of TFR on condonations, Gamma should have, by virtue of consistency of its application, been afforded the opportunity to apply for condonation. Gamma was not given the opportunity to apply for this by Transnet internal audit and the then GCEO, Ms. Maria Ramos. The outcomes could have been different had he been afforded that opportunity. That's what you've said, correct?
That is correct.
Yes.
Can I comment?
Yes, certainly.
That's why I say the outcome could have been. The outcome could have been the same. Even though it would have gone through whatever condonement application, it could have been the same.
Yeah.
Yes.
Just incidentally, did Mr. Gamma apply for condonation?
I don't know.
I see.
I really don't know. Yeah.
And then at paragraph 9...
I'm sorry. Did you try and find out whether he had at any stage applied for condonation?
Chairman, I did not, because as you can imagine, I'm dealing with this matter almost 7 months after Gama was dismissed. And I was not communicating with him or with anybody else. But that would have been the duty of KPMG, in my interpretation, to find out if it did. I don't know.
Now, isn't the position that an employee who seeks condonation must request condonation or apply for condonation?
That is correct.
Now, Mr. Gama was a very senior employee in the company. From what I understand, from what I heard in the past few days about TFR at Transnet, it seems that TFR was the largest division at Transnet. Is that correct? So we are talking here about somebody who was employed as CEO of the largest division within cabinet, within Transnet.
Within Transnet.
You're talking about somebody who was leading his division with a lot of people, employees and other managers under him, who is supposed to have had knowledge of these policies and processes we are talking about. Is that not so?
That is correct, Chairman.
Because he would be needed, his job needed him to even guide those under him on these policies, isn't it?
That is correct, Chairman.
Therefore, you are dealing with somebody whom you are supposed to expect to have known of the existence of this condonation process, and that an employee can apply for it if the employee wishes it to be invoked. Is that right?
He should have known, yes.
And if he did not apply for it, there may be no reason why you or the board should bother to come to his assistance when he elected not to use it when he knew about it, isn't it?
Yes, Chairman.
You accept that?
Yes, I do, Chairman.
Yes. So the question that arises is that when the issue of condonation arose within the context of his dismissal dispute, I would have expected your attitude as well as the attitude of the board to be that, well, one, we are not here dealing with a lowly employee. We're dealing with an executive who knows the policies of the organization. First of all, did he apply for it? Did he want condonation? Because if he wanted condonation, one would expect that he would have applied. Did he apply for it? And if the answer is he did not apply for it, then the next thing is, why should we assist him with something that he was aware of and could have invoked and did not invoke? That is the attitude I would have expected. Do you think that's a fair expectation?
Chairman, I don't have facts whether he did or whether he did not. But when you look at the quantums of some of the condonations that we had to deal with, which ran into billions of rand, and those were granted subject to disciplinary action. I don't have a record of whether did he or did he not. I really don't have that record.
No, I accept that you don't know whether he did or he didn't, but that's part of my question. because I am saying, since you knew as the board that you were dealing with an executive who ought to know the company policies and so on, when this issue of condonation was raised in the context of his dismissal, my expectation is that the first reaction from you and the board ought to have been, did he apply for it? Because this condonation, you have to apply for it as an employee if you want it to be invoked. And I'm concerned about why you didn't ask that question, or you didn't try to establish whether he did apply for it.
Chairman, my interpretation is that the KPMG forensic should have looked into whether he did or not. That is why there's an element of doubt as well, whether he would have been granted or not granted that condonation, and whether he would have been disciplined or not disciplined, based on the other similar matters of contracts which ran into billions, and no disciplinary action was taken against those individuals, except in 2011, when the offenses were committed in 2005.
Yes, but maybe I'm not articulating my concern as clearly as I should. I accept that you say you don't know whether he did apply for condonation. I accept that you say you did not investigate that issue. I accept for present purposes that you think KPMG maybe should have looked into that issue. My issue is, my expectation is that before you went to look into any number of previous cases where condonation had been granted, I would have expected you and the board to say, oh, there is this issue of condonation being raised, but condonation has to be applied for. We want to find out whether he did apply. And if he did apply, what was the outcome of that process? Before you could go and dig and dig and dig. That's my question. I'm wondering why that's not the attitude you and the board took. And I'm asking whether you think my expectation of what your board should have done is unfair, or you accept that it's fair.
I think it is fair, Chairman, and I empathize with your position, and of course these things happened many years ago. I still don't know if it did apply. It would be of interest to still get that information, whether it did apply or not. And at times this application for condonation was a strange thing, because at times it came via Transnet internal audit, and now my recollection now as an executive, which is maybe in 1996 or 1997, in a situation like this, the request for a condonation would not just have come directly from the individual. It would have come in partnership with the Transnet internal audit, so that it's put on record that as you get this condonation, you also get a final written warning. That was the culture then, but that's many years ago.
Yes. Yes. Okay, no, that's fine. Mr. Mybeck?
Thank you. Mr. Mkwanazi, you say that KPMG should have looked into this, but of course you agreed to reinstate Mr. Gama long before KPMG completed its investigation.
That is correct. As I indicate, there was a preliminary report by KPMG. If you recall, when Transnet responded to the public protector letter in April of 2011, there was a preliminary KPMG report attached. Now, I've not seen that report, and it's also true that even as early as before the end of January, there was a KPMG preliminary report and other reports from Transnet internal audit on irregularities in procurement. They are there, those reports were there, and so they articulated these irregularities, and also they articulated the wrongdoings, the sanctions, the no sanction. So there was that element of doubt then that maybe there was lack of consistency.
But Mr. Mkwanazi, you dealt with Mr. Gama on the basis that he hadn't been offered or applied for condonation. That's the basis upon which you dealt with him.
Yes,
yes.
In that, had he applied?
Yes. So let's go then.
Would have been different. Yeah.
Let's go to the last sentence of paragraph 9.4. You say, in effect, if he had applied, the outcome could have been different. Is that right?
That is correct.
Let's go to paragraph 9.5. The incoming Transnet board of 2010, which was dealing with these mega projects that were frankly not managed well, had to somehow try and deal with the Gama matter on the assumption that he would have been granted condonation. I don't understand, because if you just bear with me, at the end of paragraph 9.4, you say, well, you don't know if he would have, but then you treat him with the benefit of the doubt that he would have been.
That is correct, but then having said you treat him with the doubt, you then just don't leave it there. You then have got to deal with what type of sanction, and would you then have given a Mr. Gama?
I'm sorry, Mr. Maybeck. Please don't forget your line of thought. There is something that I should have asked earlier, but I thought I would ask later, but I think it comes in now. Mr. Mkwanazi, I think we can accept that Mr. Gama did not apply for condonation. Are you prepared to accept that, or you think he probably did, or you think he may or may not? I think by now we would have known if he had applied for condonation. There was a lengthy disciplinary process. You remember that?
That is correct, yes.
At which he was represented not just by an attorney, as I understand the position, by even senior counsel. You remember that?
Yes, I do.
And that disciplinary hearing, I'm told, the actual hearing took 14 days. And when you read the rulings of the chairperson, you can see that the matters were dealt with extensively. Now, do you think that Mr. Gama, if he had applied for condonation, he would not have told his lawyers that he applied for condonation and it was granted if it was granted, or it was refused if it was refused? He would have told them. Yes.
Yes, and he would have disclosed it.
Yeah, it's unthinkable that he would not have mentioned that he did apply for it. Isn't it?
Yeah.
Yeah. So we can accept that he did not apply for it. And actually, you do not that the issue of condonation was raised at the disciplinary hearing by his lawyers. You know that?
Yes, I recall, yeah.
So the lawyers would have dealt with all of those issues, and they would have said he applied for condonation, and if he was granted condonation, they would have said that. We would be knowing it from the ruling of the chairperson. Or if he was refused condonation, and they thought he was unfairly refused, they would have told the chairperson of the disciplinary inquiry. You accept that?
That is correct.
So he did not apply for condonation. Okay? And you either knew that he did not apply, or if you didn't know, to get to know would have been the easiest thing, isn't it? To find out, did he apply? One way is to ask him or ask his lawyers. You accept that?
I accept it, yeah.
Yes. Now, as I understand your affidavit, the door that you or the board use in order to get to reinstate him is to say Mr. Gama was not offered the opportunity of a condonation. Am I right?
You are correct, Chair.
Yes. Now, is it fair to put it that way when you are dealing with an executive like Mr. Gama? Because he didn't need to be offered condonation. He knew there was this process. He knew he could apply for it, and he elected, for whatever reason, not to apply for it. You accept that, don't you?
I accept that, too.
And if there is any unfairness arising from that, it would be an unfairness that he brought it upon himself by deciding not to apply for that call, for that process, isn't it? You accept that? You accept that?
I accept it.
Once you accept that there was nothing unfair about him not having been offered the opportunity of condonation, because he knew he could apply, he elected for reasons known to himself not to apply, then isn't the position that then there is no sympathy for him? There ought to be no sympathy for him.
Chairman, your observation is correct. And also then, Chairman, it's a strange environment, that Transnet, in that I'm not sure how many condonations were granted every year in that organization, and I'm not sure, but it was quite common, but that he didn't take that advantage in terms of that. I don't know why he didn't do it. Yeah.
But he can't blame anybody, and the board can't and shouldn't have relied on that to feel any sympathy for him, because this is a senior executive. He knows the policies of the organization. He knows these processes. And at the time, or after he had been told that he was going to face a disciplinary inquiry, he employed lawyers, including senior counsel. He had no disadvantage in dealing with these charges. He had the advantage of a legal team at his disposal to advise him. Therefore, the board, that's what I'm putting to you, did not have grounds based on condonation to feel any sympathy for him. What do you say?
Chairman, I agree with you, but the board at the time viewed a lot of other similar cases where things were done in 2005, 2006, and they hung on unresolved with no condonation for 5-6 years, and those condemnations get applied for in 2011, because at that time in 2011, we pushed through a communication in the organization that this condonation story must come to a halt. And also we elevated the authority to allow condonations to the office of the group chief executive only. And on top of that, we requested that each and every irregularity in procurement must be reported to the board and to the audit committee regularly, because these things have got an impact on how we report our annual financial statements. And also, if I recall, in terms of these irregularities, we then even said that we will voluntarily report them to the shareholder because they were an embarrassment to the organization.
Yes, but all I'm simply saying is, insofar as Mr. Gama may have been complaining that his dismissal was unfair because of condonation, the board had no grounds to rely on condonation to come to his assistance in circumstances where he had elected not to invoke that process. You accept that?
I agree with you.
Okay. Mr. Mybeck?
Yes, thank you. Mr. Mkwanazi, before the chairperson asked you that series of questions, do I understand your evidence to have been, in effect, that you said, well, look, let's assume that he applied for condonation. The worst that would have happened to him is that he would have got a final warning because that was the precedent. Sorry, you're on mute.
Worse than that. Not necessarily a final written warning, maybe worse than that. Maybe dismissal, maybe demotion, whatever the people dealing with it would have decided. But maybe worse than that, yes.
But then why did you reinstate him?
The reinstatement comes from a view that there were similar cases or even worse cases where no disciplinary action was taken for 6 years.
But Mr. Mkwanazi,
on these cases.
You've just said that the result could have been worse. It might have involved a dismissal.
I don't know. I don't know on in terms of. I'm losing my thoughts a little bit. Can you come back?
Yes, well, I mean, the real problem you have is you don't know what would have happened. But for some extraordinary reason, you dealt with Mr. Gama in the most generous fashion, and you just divined that he would have somehow have been reinstated. Or that he somehow would have not been dismissed.
That is correct at the time when this thing was being dealt with. But as I indicate, there were close to 22 other executives who maybe could have done something similar. And based on that sentiment that here are these 22 other executives who have not even been disciplined, and also based on discussions and engagements with the board, then that decision was taken that maybe a reinstatement with a limited sanction is appropriate. Yeah.
But Mr. Mkwanazi, there were people who conducted themselves, certainly that's the finding of KPMG, in the same way as Mr. Gama, and were dismissed. That was one of their findings. Correct?
That is correct, yes.
Yes, and in fact, have you heard of Mr. Salamela and Mr. Kanye,
Yes.
Do you know that they were the two people who signed the GNS confinement and then presented it to Mr. Gama and then he signed it?
Yes.
Yes. And do you know what happened to them?
I think they were dismissed.
Yes. They were dismissed. Those are two persons involved in the same misconduct as Mr. Gama.
And he was their senior. You remember that?
Yes, I do. He was the CEO of TFR.
I beg your pardon?
He says he was the CEO
He was the
of
CEO
TFR.
of TFR.
Yes. And have you ever taken the time to read the finding of Nazir Kasim SC in that case?
Who was chairperson? He was chairperson of the disciplinary inquiry relating to those two employees. You never read it?
I haven't read it, yeah.
You didn't have any difficulty with them being dismissed, did you?
I'm not sure if I was there at the time. What year was it, if I can be reminded?
It was in 2010.
I was not there.
But one would have expected that when you dealt with Mr. Gama's matter, the fact that two employees who were under him had been dismissed in connection with one of the tenders for which he was dismissed, I would have expected that you would have been informed of them.
No, we were not informed of those two employees, yes.
Yes. Did you only get to know about them much later?
I did know about it much later, yes.
Yes, okay.
Mr. Mkwanazi, let me just understand before I move on. You, as the acting group chief executive and the chairperson, when you took a decision to reinstate Mr. Gama, and where he had been dismissed on one of the charges in relation to GNS, you didn't even know that two other managers junior than him had been dismissed. You didn't even know that.
No, I didn't. No.
And if you had known that, presumably your decision would have been different, of course.
It might have been, yes, because I would have had to look at the facts, etc., and even the motivation to the board would have been different.
It
But
might
on
have.
this same matter, these individuals already have been dismissed, and the motivation would have been completely different.
All right.
When you got to know about these two employees who were dismissed, were under Mr. Gama, would it have been a few months after Mr. Gama had come back, or are you not able to indicate?
No, I don't recall, but it would not have been a few months. It was much later when one was reading about some of the goings on.
Yes.
In Transnet and in former employees, because there were many others, by the way, there were many things going on there at the time.
Yes. Okay, all right. Mr. Mybeck?
Well, it seems to me, Mr. Mkwanazi, what you did is you focused on alleged inconsistencies instead of consistencies. I mean, here were two people whose dismissals were consistent with Mr. Gama's. Why did you look at it the other way? I mean, you had the benefit.
Advocate, you are correct. I did focus on inconsistencies because my line of thinking was, why is this individual, when I say my line, even my submissions to the board and discussions with the board, why is this individual unfairly prejudiced when there are 22 others who should have gone through the same experience and nothing has happened to these? That was my line of thinking at the time, and that's the motivation I submitted to the board. And also at the time as well, I was getting dossiers, if I can use the word, on a lot of irregularities in the organization during the month of January.
Well, we'll come
2010.
to the 22 in time, but perhaps I could just ask you, so why didn't you just discipline the 22?
We did ask Brian Milife to discipline them.
Yes, so?
As a board. I don't know if he did do that. I don't have feedback on that, but I'm aware he tried to discipline 2, and he did discipline 1, Gary Peter, if I recall. And I don't know about the others. We never followed up with Mr. Brian Milife.
Perhaps you missed my point. Why didn't you just retain the dismissal of Mr. Gama and then discipline and dismiss the other 22? Why not? Why did you do it the other way around?
The point is valid. We did it the other way around because we were sensing unfairness on the sanction of dismissal. Yes.
But, well, let me just clarify something. This concept of condonation within Transnet, it did not mean that if condonation was granted, the employee would not be disciplined. Is that correct?
That is correct, Chairman.
Indeed, you have testified that in respect of some of the condemnations that the board dealt with in 2011, you specifically, as the board, instructed the group CEO, Mr. Molefe, to take disciplinary action against certain managers. Is that right?
That is correct, Chairman. Yes.
Now, I must confess that when I first read, or for some time after reading about this point of condonation, I thought that what it meant was, if condonation is granted, it means that whatever misconduct the employee may have committed in connection with that procurement will not lead to disciplinary action. But Mr. Todd's evidence and his affidavit made the distinction, and I think your evidence seems to be in line with his, to say condonation doesn't mean that you are not going to be disciplined. Is that right?
I agree, Chairman. Yes.
Now, my difficulty then is, what then is the relevance of condonation where the issue is whether the employee was dismissed fairly or not? Why is condonation a relevant factor?
Chairman, you almost need to take the discussion a little bit back. I agree that Mr. Gama was dismissed fairly in terms of the processes. But the question is, had there been a process of him even applying for that condonation, the outcome might have been different. The outcome could have been the same, frankly. Or the outcome could have been he's demoted. The outcome, I don't know what the outcome could have been. But because for whatever reason, his issue did not go through a condonation process. Yes, the outcome that came out as per Advocate Antropos.
Well, I don't understand. If the policy of the company is that employees may not do A, B, C, D, and if they do A, B, C, D, they will be disciplined, and the disciplinary process could lead to their dismissal.
That is correct.
And an employee is alleged to have committed that misconduct or acts of misconduct A, B, C, D.
Yeah. Yeah.
and a disciplinary process is then instituted, the employee, as I understand your evidence, can't say as a defense to the charge or charges against him, I've been condoned, or my non-compliance with the procedures has been condoned. Isn't it? That's not a defense
I can't say
to
that.
a charge.
No. Yeah.
So, if it is not a defense to the charge, why is it relevant to the question of whether the sanction that gets imposed on the employee at the end of the disciplinary process for misconduct A, B, C, D was fair?
Chairman, I think I will repeat myself. It's a what if. Typically, say Mr. Gama had applied for condonation, and say the outcome of that application was you are going to be disciplined, and the outcome of that disciplinary process is a dismissal. That is fair, Chairman, because he had an opportunity to apply for that condonation. Your points about did he apply or did not apply, was it granted or was not granted, are valid, Chairman. I agree with you fully. And being a senior executive that he was, your points are valid.
You see, because part of what I'm trying to understand, and Mr. Myberg is also trying to do the same, is the reasoning of the board in deciding to reinstate him. Because when one looks at the charges of which he was found guilty, I don't know in your mind, but in my mind, they are very serious for a senior executive in the position in which he was. So, and when you look at the rulings of the chairperson of the disciplinary inquiry, both in regard to whether he was guilty of these charges or not, and in regard to the sanction, they are very thorough, they are very, very detailed. And then you can see that the chairperson took care to consider the evidence and the arguments very carefully, you know. And this was an independent chairperson. It wasn't somebody who might have been involved in any maybe factions within Transnet, if there were factions. But it was somebody who was independent, a senior member of the bar. So you then say, but how could the board decide that this person must be reinstated? So you look for their reasoning. And central to the board's reasoning is the condonation process. So because that is central to the board's reasoning as to why they reinstated Mr. Khan, once you say to me, condonation doesn't mean that the employee's misconduct is condoned and he can't be disciplined anymore, then I say, but what was the relevance of condonation then? Because you have accepted that it was not a defense. It could not be a defense. You can't say when you are charged for misconduct arising out of procurement processes and say, well, I've been granted condonation, so you can't charge me anymore. So help me understand where it is relevant, because it is not relevant to the issue of guilt, isn't it? It is not relevant to the question whether the employee is guilty of the charges. Is that right?
Chairman, there are two stages that the board is trying to explain. The one is that there was a process of condonation within Transnet, but that condonation did not imply that you will not be disciplined. Now, knowing that there was this system of condonation, then the question was, when this Gama matter was dealt with, there were many other cases where condonation had not even been applied for. But I'm going back to an argument that Advocate Maibek touched on, that we don't know whether Gama would have been granted condonation. Even if you would have been granted, it would have been subject to disciplinary action. And the outcome of that disciplinary action, we don't know what it would have been. Could have been a demotion, a dismissal, etc. So that was our thinking then. Now, in fairness to what you are saying, the board would have had no ground if a condonation process had been done by Mr. Gama to deal with these matters. That board would not have had any grounds. But that board as well would have had to deal with the 22 other cases which originated as early as 2005. And that board did try to do that. I'm not sure how far Brian Mulife went, but the board did try to deal with those.
You see, for me, once you say condonation doesn't mean that any allegations of misconduct or any misconduct by the employee is condoned, it actually means that those who have the power to make the decision whether the employee is charged or not, they must do their job. What outcome happens, that outcome will happen, okay?
That's correct.
Now, so if you then say to me, you know, we found as a board that, you know, Mr. Gama was not offered condonation, my reaction is, and so what? He was not offered condonation, and so what? That's my reaction.
No,
Because I'm saying condonation would not have changed anything. If he was guilty of misconduct, the disciplinary process would have led to him being found guilty. And if the sanction of dismissal was found to be appropriate, it would have been imposed irrespective of whether he was granted condonation or not. You accept that, don't you?
I accept that. Yeah.
So I go back to my question. He was not offered condonation, and so what? That's my question. Because I don't see where it comes in.
It comes in, Chairman, in that the process was incomplete. In that the issue of condonation should have been tabled by him post this matter being elevated. But it looks like he did not. Now, then this board looks at this and says, had he applied for condonation, the outcome would have been different. It might not have been different. Yes, I agree.
But the fact of the matter is he did not apply, and because he did not apply, he should not get the benefits that he may have got if he had applied. If you want the benefits,
whether he applied or not, I don't have my facts.
Yes, if you want the benefits of condonation, whatever they may be, you apply.
That is correct, Chairman.
If you don't apply for condonation, you don't get the benefits that come with condonation. You accept that?
Agree, Chairman.
And therefore, once the board accepted that he had not applied, it should not have sought to give him benefits of condonation that would only apply if he had applied. You accept that now?
Chairman, I do not know if he applied or not. I still do not know, Chairman. But based on the record of the proceedings and also maybe whatever submission his attorney would have made, it looks like he did not apply.
Yes. So what I'm saying is that the board should have sought to establish whether he applied.
Yeah. I agree, Chairman.
And if it established that he did not apply, it should not have sought to give him the benefits of something he did not apply for. You accept that?
I agree, Chairman.
Yes. Okay, all right. Mr. Mybeck, I know that I interrupted you, but I know that you haven't forgotten your
No, I haven't, thank you.
questions. But I see we are at 25 past. Shall we take the tea break?
Certainly, thank you.
Okay, all right. We'll take the tea break for 15 minutes. We will resume at 22:12. We adjourn.
Thank you, Chairman.
Thank you, Chair.
Mr. Mkwanazi, are you ready? You are ready, that's it, Mr. Mkwanazi. We will start now, Mr. Mkwanazi.
I'm there, yes.
Okay, thank you.
Oh, okay. I'm there.
Okay, let's continue. Mr.
Thank
Maida.
you, Mr. Chairperson. Mr. Mkwanazi, before I finish off with your statement, I just want to confirm, as I understand that you make these two concessions in response to the Chairperson's questions. Firstly, you accept that you went wrong in giving Mr. Gama the benefit of not having applied for condonation, correct?
Yes, that is correct. But also, let's not forget that by the time we're dealing with this matter, Gama had taken the matter to the Transnet Bargaining Council. And in view of that, then the board had engaged Dennis Reeds, et cetera, for advice on what you may call the winnability of this case at the Bargaining Council. But yes, I do accept that
Yes, we're going
Gama
to.
should have applied for condonation. Yeah.
Yes, we're going to come to that advice that you received. The second concession that you've made in response to the Chairperson's questions is you accept that in any event, condonation and disciplinary action are two different things. Correct?
I agree.
Yes. And in fact, as I understand you, you accept that whether or not someone is granted condonation doesn't necessarily have a bearing on the fairness of the sanction of dismissal. Correct?
That is correct.
Thank you. Let us then move to your affidavit. So we've dealt with paragraphs 9.4 and 9.5. Then you say at 9.6, following a review of Mr. Gama's dismissal from Transnet, the board resolved that the sanction given to Mr. Gama was too harsh given the circumstances, as well as the fact that he should, in fact, been granted an opportunity to apply for condonation. Well, we've dealt with that.
We've dealt with that, yes.
Then you go on to say at 9.7, in view of avoiding further litigation in respect of Mr. Gama's appeal of his dismissal, the board resolved that it would be in the best interests of Transnet to settle the matter. By way of a settlement agreement, the terms of which were negotiated through Transnet's internal bargaining process. Is that what you say?
With the help of external lawyers, yes.
But you were actually the negotiator.
Not really. I was the lead negotiator,
Yeah.
if I can put it that way. But in the process, I was advised by Dennis Reeds.
I see. You were the lead negotiator.
That is correct.
And then you say, I wish further to confirm that neither the settlement nor the terms on which the settlement was made were influenced by any member of cabinet at the time. You stand by that?
That is correct. Yes, I do.
Now, you remember if we go back to the beginning, you confirmed that you had been asked to explain the decision to settle with Mr. Gama and the terms of the settlement agreement. You remember being asked to do that?
Yes.
Where do you
Asked
deal?
by who, by the way?
By the Commission. That's why you put up this
Oh, yes.
declaration.
Yes.
Why do you not deal in this declaration with what was paid to Mr. Gama by way of salary, short-term incentives, long-term incentives, costs? of his bargaining council referral, costs of his disciplinary hearing, costs of the High Court proceedings. Why do you not deal with any of that when you were asked to?
Why do I not deal with are you talking about the letter from the commission?
Yes.
Yes, he's talking about that letter here.
Yeah.
You might wish, I'm sorry, Mr. Mkwanazi. Mr. Myberg, you might wish to take him to the letter first.
Yes,
and just highlight the specific issues, and then he can respond.
The letter is attached to your affidavit. You find that at page 21.1.
Oh, okay. Yes.
And you will see at page 21,
yes.
21.3, there's a heading reinstatement. 21.4, retrospectivity of reinstatement. These are all contentious issues. Final written warning, costs. Those are all the terms of the settlement agreement. Then at 21.6, paragraph 7, Chairperson of the Commission has directed me to request you to furnish the Commission on or before 20 August 2020 with an affidavit or a firm declaration in which you explain why you and or the Board of Directors of Transnet considered it correct or proper or justified to conclude the settlement agreement on the terms on which you concluded it. So that's not just reinstatement. That's why did you give him a final warning that had expired? Why did you pay him full back pay, LTIs and STIs? And why did you pay his costs? You don't address any of that in your declaration.
If I recall, I might not have addressed it, but if I recall, I wanted to submit a supplementary affidavit, which I have not yet done. And the idea was that I would deal with those issues in more detail.
So let's firstly deal with whether or not you dealt with it in this declaration. Can you please just give us a straight answer?
I don't think I have.
Well, have a look at it and tell us.
I do not think I have, yes.
Do you need an opportunity to look, Mr. Mkwanazi? Because I'd like a straight and definitive answer, please.
No, I can look at the issues that are on that request for an affidavit, yes.
I think Mr. Myberg is inviting you to look at your affidavit to see whether you do deal with the issues that he is raising with you.
In my affidavit that I've got in front of me, I don't deal with those issues, but I did indicate to my lawyer that I wanted to make a supplementary affidavit.
Mr. Mkwanazi, you also don't say anything about wanting to put up a supplementary affidavit in this affidavit, do you?
No, I didn't say anything, yes.
Why not, if that was your intention?
Or maybe let's ask, when did you think of the idea of a supplementary affidavit? When did you think of the idea of a supplementary affidavit?
A long time ago. In actual fact, I've got a draft, but my lawyer is supposed to have a look at it first before it comes to the commission.
Oh, but quite some time after you had delivered this one to the commission.
That's correct. I don't know the date of that one, but it is dated. Yeah.
Okay, all right. Mr. Myberg.
Thank you. And then at paragraph 10, you say, and you've dealt with this already, when Brian Molefe joined the Transnet board, he was instructed to take disciplinary action against all officials implicated in the KPMG and Konki report, correct?
That's correct.
And then you go and deal with that further. You say at 10.5, the board at the time left the rest of the disciplinary processes in the hands of Mr. Molefe. And here you say there could have been another 12 senior managers who could have been disciplined, correct?
That is correct.
Earlier on in your evidence, you spoke about 22. Can we reduce that to 12?
The number is actually higher, but let's remain with 12.
Okay.
Yes, it could be 22, because then I've got to go back and take them out by line item or by name. But I'm happy with 12.
Well, here you say 12.
Yeah, I say 12, but I'm saying it could be higher.
I see.
I would have to go back to the report and actually generate a list.
Then if we go over the page to paragraph 11, your conclusion, the above factors, information at the board's disposal, as well as the legal opinion sought by the board were considered. Now we're going to come to the sequence and chronology of events in some detail when I take you through it, Mr. Mkwanazi, but the opinion of which firm of attorneys are you referring to here?
It's Dennis Reeds.
All right. So are you saying that the Denise Rates opinion was before the board on the 16th of February?
Yes.
All right.
There were two pieces of opinion by Dennis Reeds, if I recall. There was one which you would call an abridged version, and then there was another one which was a more detailed version substantiating what was in the abridged version. Yes.
All right. Well, then I think I understand it. So you are right. There were Denise Rates opinions, or certainly input from Denise Rates, in a document dated the 15th of February, the day before the board meeting. And then on the 22nd of February, a few days later, there was the more expanded version, correct? All right, we'll come to that.
Yes.
So let me then... So is there anything else you want to say in relation to your declaration and your statement before I move into my questioning of you?
At this stage, you are going to come back to the Dennis Reeds and things?
Yes, absolutely.
Okay, good.
So let me start off, and I'm going to run through the chronology of events. Amongst the files that we've put up is a bundle 2 where we've got a very long extract from the evidence of Barbara Hogan. And perhaps I should start there, yes.
Okay, I've got bundle 2 in front of me.
So could I take you, please, Mr. Mkwanazi, to page 216. This is the extract from the evidence of Ms. Hogan before this commission.
Page 216.
216.
Yes.
I thought perhaps the one way to speed this up is for me to take you to page 250. And to read to you a paragraph from her affidavit or statement that was read into the record. At page 250, yes. Line 10. Are you there?
I'm sorry, Mr. Mybeck. Which bundle?
Bundle 2,
Bundle
Mr.
2.
Chairperson.
Okay. Okay. 250. Yes, okay.
From line 11, I was shocked and disappointed when President Zuma informed me that he was adamant that Mr. Gama was the only choice for the group CEO. Now, just to place that in context, Mr. Gama was suspended on the 1st of September 2009, there was then an attempt to fill a vacant CEO position of Transnet. And when Ms. Hogan presented the name of Mr. Maseko to former President Zuma, evidence was that he was insistent that Mr. Gama be appointed. And this is what she said: "I was shocked and disappointed when President Zuma informed me that he was adamant that Mr. Gama was the only choice for the group CEO. I informed him that that was not possible and that Mr. Gama was not the board's choice, and I could not override the board as they had undergone a very professional selection process. I further informed President Zuma that Mr. Gama was the subject of an inquiry into procurement irregularities and that it would be very messy to appoint a group CEO who could potentially be facing fairly serious charges. President Zuma said that if that was my view, no appointment whatsoever would be made at Transnet until Mr. Gama's disciplinary process was over. We agreed that I'd provide him with more information." You've no doubt heard of this testimony before.
Yes, I've never seen it in this way, but I've read about it. Yeah.
Yes, you've read about it. So there was then a hiatus because Ms. Hogan had to wait until the outcome of Mr. Gama's disciplinary inquiry. And then let's go to that part at page 267. At line 22.
Okay.
No, you know, I waited the outcome of the disciplinary hearing. But once that outcome, once he was found guilty on 3 counts and was dismissed on all 3 counts, the Deputy Minister and myself initiated a process to appoint a new Transnet board. And that was then a year after of this happened. And it was then towards July, August 2010. You see that?
I see that.
And then if I can ask you please to go to page 277. Ms. Hogan then attempted to constitute a new board or have a new board appointed, but she says at line number 3 at page 277.
Which line is that? Can I advocate what paragraph?
Page 277, line 3.
Yes.
She says, well, Mr. Gama was fired at the end of 2010. We know that was in July. And I was fired by the president at the end of October. A few lines down.
He was fired on the 29th of June.
28 to 29 June,
yeah.
Yes. I was fired by the president at the end of October. And then at line 10, Mr. Molefe was then appointed as the CEO of Transnet. Line 14, then Mr. Gama was reappointed. So this is where you enter the scene. As the CEO of Transnet Freight Rail, a couple of months later, on the grounds that they had reviewed the sanction and that they had an independent review. I don't know, I do not quite know what that was about. Chairperson says this was now a different board from the one that was in existence during your time. This was a board, said Ms. Hogan, that had been appointed by Minister Gigaba, who succeeded me. And you, we know, were the chairperson, correct?
That's correct.
Now, Mr. Mkwanazi, this is also something I can take you to other passages in our evidence that received a lot of publicity. Mr. Gama's suspension and disciplinary action. It was something of a political hot potato, not so?
That is correct.
And you knew about that?
Yes, I knew.
Did you know that Ms. Hogan had been or lost her post as a minister in these circumstances?
I did not know that in detail, but I know it now, having read what I'm reading.
Now the new minister, Mr. Gigaba, he was appointed as I understand, Chairperson, you'll correct me if I'm wrong, with effect from the 1st of November.
Yes. Yeah.
So you then met, did you, with the new minister? And the chairperson has asked you, and you confirmed you did that in October, before he had even been appointed.
That is correct, Advocate.
Okay.
Chair.
And you set out in your declaration what it is that you discussed.
That is correct.
Could we go, please, back to your declaration? Bundle 4A.
Bundle 4A.
Yes.
Wait.
And I want to take you to page 4.
Okay, page 4. Okay. To page 4. Yes, I'm on page 4.
You say at paragraph 4.3.
Yes.
If I can ask you to drop down to 4.3.3. He was somehow aware of problems in the procurement of suppliers and services for mega projects in Transnet. Did it surprise you that he was aware of that?
The answer is no, it doesn't surprise me because maybe some of these were already in the media, or maybe he had some inside information, say from Transnet, on what could have been happening in procurement.
Mr. Mkwanazi, was it also in the media that former President Zuma was a devout supporter of Mr. Gama?
Yes, it was, and maybe even more in the media, but yes, it was in the media.
And you were aware of that?
Yes, I was aware of that.
So let's go to paragraph 4.3.4. He was also under the impression that disciplinary matters at Transnet were racially based, and it's the next part of the sentence that I want to focus on, and that there was a condonation process at Transnet that was generally used to deal with deviations within Transnet. You seem to know a lot about
that paragraph.
Yeah. How do you think he came to know about that? You smile.
You know, Advocate, you need to understand how state-owned entities operate. They operate in very strange ways, where within these entities, some of these ministers have got sources of information, particularly these big SOCs like, say, ESCOM, Transnet, and I don't know who else. But I suspect somebody inside the organization would have briefed the minister about that, or maybe even outside of the organization. In that case, I'm assuming that it could have been Kama himself.
Yeah.
I'm sorry. Do you mean that even if a minister is not a minister of public enterprises, very often they have people within the different SOEs that maybe tell them some of the matters that are going on in those SOEs, or what?
That is what I mean, Chairman.
They have a lot of interest in the SOEs.
That is what I mean, Chairman. Maybe to take it a little bit further, Chairman, you'll have to understand that some of these ministers and members of parliament have got companies that somehow, I suspect, have got an interest in what is happening in these companies, in these state-owned entities. So which is why they have an interest of tender opportunities, if I can use the word, of whether they exist or not.
Yes. Well, obviously, Mr. Mkwanazi, you see I'm laughing.
Yes.
So you, of course, you were involved in different SOEs at different times and in different capacities. So I take it you know what you're talking about. Is that right?
That is correct, Chairman. That is correct.
So a lot of the ministers would have companies and they would be looking at tender opportunities in the various SOEs.
That is correct, Chairman.
Yes. Yeah. Okay.
Thank you.
Thank you.
Mr. Chairman. Mr. Mkwanazi, sorry, just before the Chairman asked you a question, I just want you to confirm that you said, in fact, that the Minister might actually have heard about this from Mr. Gama himself, correct?
Yes, I did. Let me maybe expand on this. The Chairman will recall that at some stage while Mr. Gama was on suspension, Mr. Gama was lobbying virtually many ministers. I don't know which ones now, but yes, therefore my assumption is that maybe he had shared this, or if it was not him, it could have been any other employee, because the employees in these state-owned entities are strange animals to a certain extent, because they've got certain direct lines to ministers, which even me as chairman at the time might not have had. Yeah.
Well, when Ms. Barbara Hogan gave evidence about the matter of Mr. Gama, she also did say that a number of politicians, including ministers, went public while the process of recruiting or appointing a group CEO was underway, and when there was talk of Mr. Gama being suspended or being charged, or when he had been suspended or was being charged, there were some politicians who went public calling for Mr. Gama to be appointed as the group CEO, and saying that the charges against him were unfair or were trumped up or were intended to prevent him from being appointed as group CEO of Transnet. Ms. Hogan gave that evidence, and I think at the time when she gave evidence, newspaper clippings were included in the bundle that was used, and indeed, I think there was a newspaper article where I think Mr. Mantashe was said to have made statements as well supporting Mr. Gama. I think Minister Nyanda, General Nyanda, I think he was minister at the time, he was also reported in some article to have also come out, as well as Minister Khadebe. So that's in the public domain, and it's before the commission in terms of the bundles relating to Ms. Hogan's evidence. So that part was referred to.
And as I understand it, you knew about all of that.
It was in the news.
Perhaps I could just ask you to turn to page 253 of Bundle 2. 253.
Okay. 253. 253.
Yeah.
Okay, wait. 253, is it Ms. Barbara Hogan's bundle?
Yes, at the top. Again,
Yes.
it's
Yes.
quoting from her statement. Mr. Gama was formally charged by Transnet and later suspended on 1 September 2009. Immediately before and in the days following his suspension, Minister Jeff Radebe, Gama will become CEO. Minister Simpiwe Nyanda, Gama is being persecuted like Jacob Zuma, and also ANC, the SACP, the South African Transport Union, and the ANC Youth League under Julius Malema at the time all issued strong and harsh statements in support of Gama, accusing Transnet of persecuting him. This was reflected in numerous statements and reports in the media, which I attach. You see that?
I see that.
Now, are you suggesting to the chairperson that when you met with the new minister, or soon to be appointed new minister, Igaba, he never spoke to you about or mentioned Mr. Gama?
He did.
Yeah.
In my opening line or paragraph, I do indicate that I met Mr. Kikaba towards the end of October. And amongst a number of issues, he was talking about transformation in the context of black suppliers not being given an opportunity, particularly black legal firms, and also African women not being elevated to top positions. And of course, he mentioned the Gama matter and felt that the sanction in the Gama matter was too harsh or something, because there was this condonation process at Transnet that had not been followed. He did mention something.
Why did you not put that in your declaration?
Yes, I did.
Were you going to put that in your supplementary affidavit, perhaps?
No, it is there. Let me check what folder it's in here.
I think, Mr. Mkwanazi, what Mr. Mybeck is talking about is that you didn't mention in the affidavit that he raised the issue of Mr. Gama. You just said that he raised the issue of condonation from deviations.
If you read on page 4 of my submission,
yes,
paragraph 4.3.4, he was under the impression that disciplinary matters at Transnet were racially biased, and that there was a condonation process at Transnet that was generally used to deal with deviations within Transnet.
He was talking about the Gama matter under that.
That is correct, as one of the matters, yes.
Yes. Oh, okay. Well, I must say that when I read your affidavit and I came to that, because you didn't refer to Mr. Gama or his case as such,
yes,
I had a strong suspicion that he must have been talking to you about the Gama matter, but you are now confirming that he was talking about the Gama matter. Is that right? You are confirming that?
That's correct, yes.
And he said that the sanction of dismissal in the Gama matter was too harsh, or something, or words to that effect.
He was basically trying to indicate that there was racial bias against African executives in a Transnet, in that African executives were dismissed in disciplinary issues, and yet white executives were not even charged or disciplined in procurement issues.
Yes. When he referred to the issue of condonation, of the condonation process or a condonation process at Transnet, under that, for 4.3.4, was he saying that condonation had not been used in regard to Mr. Gama, and that should be looked into?
He was not specific that it should be looked into, but he was generalizing that there was this process, etc., etc. And yes, here's this executive who has now been dismissed.
Yes, yes. When he said the sanction of dismissal in Mr. Gama's case was too harsh,
He was basing it on the public protector letter as well, if I recall.
Oh.
And yes, there was, by that time, there was a public protector letter on the 22nd of December.
Yes. When he spoke to you, did he have that documentation with him, or he was just referring to it because he knew it?
No, I didn't refer to it at all. No, I might be mixing things here, because the letter of the public protector only came out on the 22nd.
Oh,
the letter
okay.
from Member of Parliament, Mickey Ventura,
Yes.
came out on the 4th of December.
Oh.
So there would have been no linkage.
Oh, okay. But so what was he basing his view on, that the sanction of dismissal in Mr. Gama's case was too harsh, as you recall? What was he basing it on? On the racial issue?
In a nutshell, what he was trying to say was white executives get away with much more serious offenses.
Yes. Okay, and black executives would be dismissed for less serious.
That is correct.
Yes. Okay, all right.
That is correct.
But all of these matters that you set out under 4.3, that is 4.3.1 up to 4.3.4, were matters that he was asking you as the person he was offering the position of chairperson of the board. He was asking you to look into seriously at Transnet.
As a board, yes.
As a board, yes.
Yes.
Okay, all right. Mr. Maybeck?
So was it apparent to you that Minister Gigaba had been holding discussions with Mr. Gama or not?
At the time, no, but I'm aware that Mr. Gama had met the other ministers and even met the president, if I recall, based on even Ms. Barbara Hogan's submission. I was aware that Mr. Gama was running all over the show trying to get sympathy from various organizations.
And when Minister Gigaba told you that he thought the sanction of dismissal for Mr. Gama was too harsh, what sanction did he have in mind?
John, please advocate. I've got not to.
You did not ask him? Or he did not offer
No.
any?
I did not ask him. He didn't volunteer as well.
Yes. Okay.
Was it clear to you, though, that Minister Gigaba would have been in favor of the reinstatement of Mr. Gama from this discussion and his statement that he considered the dismissal too harsh? Was that clear to you?
Not necessarily reinstatement. The question was the fairness or unfairness of that process, which I did then pose to my legal advisors later on. And they looked at it from two ways, if I recall, who was Dennis Reitz, the fairness of the process itself, and they concluded that the process was fair. And then my legal advisors as well, the fairness of the sanction and the fact that the matter was now going through the Transnet Bargaining Council, and therefore weighing the odds of winning or losing at the Transnet Bargaining Council. Those are the two things that Dennis Reitz helped me with, if I recall. And then later they helped me to draft a letter to respond to the public protector on some of the related issues.
Mr. Mkwanazi, that really doesn't answer my question. Let me perhaps put it another way.
Yes.
Was it clear to you, further to this discussion with Minister Gigaba, that he at very least would have been in favor of a settlement then with Mr. Gama?
Not really. It was not clear to me. You need to understand that in my negotiations with the subcommittee of the board of this so-called settlement, at some stage I wanted Gama to take a demotion and at some stage, as part of the negotiations, I had put in various things. I had refused to offer him whatever positions he thought he would get. So I don't think that could have been something that he thought I would do. But yes, as I looked into it on behalf of the board, I had to look at the fairness, unfairness, and the probability of winning or losing at the bargaining council.
But Mr. Mkwanazi, again, that's not what I asked you. Could we just have a straight answer and then I'll move on? Was it clear to you, further to this discussion, that Mr. Gigaba at least would have been in favor of a settlement with Mr. Gama, yes or no?
Not necessarily a settlement, because, hold it. From where I sat, I needed advice from legal experts on how to deal with this matter, because now this matter was going to the Transnet Bargaining Council. So, yeah.
Well, the one thing which you have said, Mr. Mkwanazi, is that Mr. Gigaba did say that the sanction of dismissal against Mr. Gama was too harsh. Is that correct?
I think so. I think he did indicate that...
or was harsh?
He felt it was unfair.
It was unfair.
Yes.
Yes. Now, based on what he said to you, which you understood to be the grounds for him thinking it was unfair, from what you said to me, it seemed clear that it was implied that he thought that Mr. Gama should not have been dismissed. Would you agree with that?
I would agree with it, but it didn't understand the dynamics of a disciplinary process and also the outcomes.
Yes, no. All I'm simply saying is that based on his discussion with you in regard to the matter of Mr. Gama, it seems that it was implied that his view was that Mr. Gama should not have been dismissed, because you said he said white executives do commit more serious acts of misconduct and don't get dismissed, but black executives get dismissed even if they have done something less serious.
No, he didn't say that he should not have been dismissed. It was
No.
unfairness of the process.
Hang on. I just want to make sure you understand. You have not said to me that he expressly said Mr. Gama should not have been dismissed. You have not said that, okay? And I understand that you have not said that, but what I'm putting to you is what seems to me to be what was implied. But you must, once I put the proposition to you, you will indicate if you say you don't share my thinking that it was implied. My thinking is that if he says the dismissal was harsh or was unfair, and he advances as the reason that white executives don't get dismissed even when they have done or committed more serious offenses, it seems to me that he was saying if Mr. Gama was a white executive, he would not have been dismissed. That seems to be implied to me. Do you think I'm being unfair to him?
Chairman, I agree with your interpretation, but then there is a different interpretation that then says, even in reviewing that process with Dennis Reeds, the outcome could have been different.
Yes, no, but at this stage, I just want us to stay with what we make of what he said to you, that is Mr. Gigaba.
Yeah.
So I understood you to be saying you agree with my interpretation of what seems to be
Of racism.
implied. Yes, you agree with that. Okay, all right.
Yes.
Okay, Mr. Maybeck.
Yes, thank you. Just so that I have it clear in my mind, he considered the sanctioned dismissal too harsh, correct?
He didn't use those words, no.
Well, that was the note I took of your evidence.
No, unfair was the word.
Because I was
Unfair
going
was the
to
word.
suggest to
And
you,
therefore, that is why as well, when I briefed Dennis Reeds, I briefed him on the basis of unfairness on two issues, on the process itself, which they came out and said it was fair. And then on the sanction itself, then they also created doubt in view of the fact that this thing was now going to the Transnet Bargaining Council.
all right, we'll come to that. Let me then,
I just wanted to say, I had also thought Mr. Mkwanazi had used harsh or too harsh earlier on, but I may be mistaken.
Let me explain where the hash comes from.
Yes.
When we're deliberating at board in February or late January, that is where the statement of hash was coming from some other board members.
Okay.
you see,
Yes, that statement did come out.
Mr. Mkwanazi, really what I wanted to put to you is that my note reflects that you said
Yeah.
that Minister Gigaba said dismissal was too harsh, and I wanted to put to you that that's precisely the basis upon which the board in a few months' time reinstated him. The minute says dismissal was too harsh. Was that just a coincidence?
Maybe, but I'm aware that the board, some members of the board did propose that, and even the resolution of the board did capture such a statement.
All right. Let me carry on with the chronology. So this is a meeting you have in October. There's some reference in the...
I'm sorry,
I beg your
Mr.
pardon.
Maybeck. Please don't forget
No, I won't.
what you have in mind. Let me go back to this issue of hash. Mr. Mkwanazi. There can be no doubt, can there be, that Mr. Gigaba must have thought that the sanction of dismissal against Mr. Gama was too harsh. Because
He might have thought that, yeah.
because the statement he made to you when he said whites commit more serious acts of misconduct and don't get dismissed, in the context, it could only have meant that he thought that dismissal was too harsh. You agree?
He thought that, yes, I agree.
Yes, okay, all right.
Thank you, Chairperson. Mr. Mkwanazi, let's then move forward from October. There's a statement in the papers that says that the new board commenced its duties on the 13th of December 2010.
What age is that?
I'm asking you to confirm that the new board commenced its duties on the 13th of December 2010. Is that correct?
Is it bundle 4?
No, I'm asking you, when did you commence your duties, the new board?
It could have been December 10.
Yes.
Or December 13.
It was actually December 10.
I'm not sure now.
But somewhere in around December 10, 13 or thereabouts.
Middle of December.
Yeah,
Yes.
okay.
The middle of December.
That's correct.
All right. Now, if you go to bundle 2, Can I ask you please to turn to page 24?
Can I go to bundle 2? Okay. Page 24.
Yes, that's the public protector's complaint.
Okay. Page 24.
What page?
Page 24, Chairperson. So this complaint you received really within a week or two of commencing your duties as the new chairperson, correct?
That is correct.
I'm sorry, Mr. Maibek. You made a certain point about the use of the sanction being too harsh a few minutes ago. I just want to follow up on that before you proceed, otherwise forget. Mr. Mkwanazi, Mr. Maibek just asked you a few minutes ago whether it was coincidental that you said earlier on that Mr. Gigaba said the sanction of dismissal was too harsh, and we know that later on you said no, he said it was unfair, but he was asking
It was unfair.
you. Yeah,
he was questioning the unfairness, yes.
Yeah, you said that afterwards. He was asking whether it was just coincidental that the board also used the same terminology. You have responded to that. I'm not asking you to respond to that one. I want to put this to you that, or you want to say something?
Yes.
Yes, yeah. Say it.
No, continue, Chairman.
Oh, okay, all right. No, I want to say, when I saw that paragraph 4.3.4 of your affidavit, where you say, have you lost connection, Mr. Mkwanazi?
No, I'm there, Chairman.
Oh, okay. I just want you to get settled.
Paragraph 4.3.4.
Yeah, that's the one we were referring to.
Yes.
Yeah.
Yes, upon.
So where you said one of the issues that the minister asked your board to look into was the issue of condemnation processes in relation to procurement matters, deviations, and so on. So,
that is correct.
So I found it interesting that one of the issues Mr. Gigaba raised at that first meeting was this issue of condonation from deviation in procurement processes at Transnet, and the basis on which the board ultimately reinstated Mr. Gama was condonation as well. Do you want to say something on that?
Chairman, your analysis is correct. The basis was condonation and the fact that the matter now was going to the Transnet Bargaining Council, and there was a doubt whether we would win the case as it goes to the Bargaining Council. Yes.
Yes, but what my context was, here is Mr. Gigaba meeting with you, the first meeting he has with you where he offers you the position of chairperson of the board of Transnet and conveys to you issues that he must have seen as issues of priority that your board should look at. He raises this issue of condonation. And of course, you have now confirmed that he did discuss the Gama matter with you. And then a few months later, the board uses condonation to actually justify its decision to reinstate Mr. Gama. So there seems to be a connection in my mind between his suggestion of condonation and the reinstatement. You agree?
There is a link, yes.
There is a link. Okay, thank you. Mr. Maiba.
Thank you. Mr. Mkwanazi, I was going to take you to the Public Protector's letter addressed to you at page 24, bundle 2, on the 22nd of December 2010, a week or two.
Yes. I've got it in front of me.
A week or two after you took up your position as the new chairperson. I just wanted to confirm that in the second paragraph, it reads, the complaint alleged irregularities in procurement at Transnet, further that the then Transnet board had unfairly conspired to prevent Mr. Gama from successfully applying for the vacant post of Group Chief Executive, which was about to be vacated by Ms. Maria Ramos. In a meeting with him, Mr. Gama alleged that the motive for his suspension could only have been to scupper his chances of successfully applying for the post. And then the following, and if you go over the page, 25,
yes.
If you look at Roman numeral 4, that there existed internally a procedure for condoning exceeding limits in respect of transactions, etc. The very point that Mr. Gigaba had raised with you, correct?
That is correct.
Now, I want to take you, please, to... Sorry?
You want to say something, Mr. Mkwanazi?
No, Chairman, nothing.
Oh, okay. I thought there was something you wanted to add. Okay, Mr. Maybeck?
Yes, thank you. Now, we know that you then appointed in the next year, early in the next year, KPMG and Nkonki to investigate this complaint, correct?
That is correct.
Could I take you, please, to bundle 1, page 811.
Bundle 1, page 811. I've got it, yeah.
Now, this is a letter from KPMG and Nkonki, dated the 12th of January 2011, setting out...
Just wait for me, Mr. Maybeck.
I beg your pardon, I'm so sorry.
I haven't received the bundle yet. Yes, you may proceed.
Thank you. This is a letter dated the 12th of January 2011 from KPMG and Nkonki, where they set out their terms and conditions of engagement. Do you see that?
I see it.
Now, that letter is addressed to Mr. Mpoma, General Manager, Legal Services. I could direct your attention to paragraph 1. It says, pursuant to our meeting on 11 January, we confirm and thank you for requesting us, etc. Did you attend that meeting on the 11th of January?
I co-signed that document.
Yes, I know that.
My signature is at the bottom. Yes. I don't recall if I attended it, but I co-signed that document.
But might you have attended the initial
Yes.
briefing meeting?
I don't recall the meeting.
So what you presumably will agree is that you asked Mr. Mpoma to assist you with investigating the Public Protector's report, correct?
That is correct, yes.
And that's presumably why he must have at least have attended this meeting, and then the letter setting out terms of engagement is sent to him, correct?
Is correct.
If we go to the end of that document at page 820, you confirm then that you ultimately signed this document on the 24th of January.
That is correct.
So, Mr. Mkwanazi, Mr. Mpoma agrees with you that you tasked him with assisting him with responding to the public protector's complaint and investigating it related to Mr. Garment.
That's correct. Yes.
What Mr. Mpoma says is that right from the outset of his involvement in this project, you told him that you had been instructed to reinstate Mr. Gama.
Not in that fashion.
Right.
The instruction was, can you look at the fairness or unfairness of the Gama disciplinary processes?
So who told you to do that?
That was my understanding in terms of the shareholder instruction. It was not in writing.
Was that Mr. Gigabe at the October meeting?
That is correct.
So now we can add
That is
another
correct.
paragraph to your affidavit.
I'm not sure. Can you?
Well,
Continue.
so far you've told the chairperson, and these are critically important things. So far you've
Yes.
told the chairperson that what we can add to your declaration is that Mr. Gigaba was of the view that Mr. Gama's dismissal was too harsh. Now, further questioning, what you say can be added to your affidavit is also that he asked you to review the dismissal of Mr. Gama. Correct?
I'm not sure it's the fairness or unfairness. Yes, correct.
Tell us what instruction he gave you, please.
I think I touched on it a little bit in my opening remark in paragraph 1.3.4. Is that he felt that the disciplinary process on Gama was unfair, based on his assumption that white executives who did similar offenses were never dismissed, but he didn't have facts. He was just questioning the unfairness. So then I took that request to look at unfairness to Siabonga Mapoma and also to Dennis Reeds. And also knowing very well that now there was this Transnet bargaining council route. Yes, I did have a meeting with Dennis Reeds to look at that unfairness.
Mr. Mkwanazi, please can you just focus on what I'm asking you?
Yes.
You said just now that you were asked to review the dismissal of Mr. Gama.
I wouldn't call it a review, but...
Well, what would you call it?
Review. To review the fairness or unfairness of the dismissal.
Well, then you and I agree with one another. So
Yeah,
Mr. Gigaba asked you to do that.
Yes,
And he was of his own view that it was unfair.
that is correct.
Before you proceed, Mr. Mybeck, you say, Mr. Mkwanazi, he asked you to, or he thought that he said the process, the disciplinary process had been unfair, but you say
That is correct.
what he put up, what he told you in support of that was how white executives were treated
That is
compared
correct.
to black
He
executives.
racialized it, yeah.
Yes, he racialized it, yeah.
That's
And
right.
now, as I see it, that has got nothing to do with the process as such. Of course, he might have put it that way. Obviously, I wasn't there, I don't know. So, process really is about whether the procedure which was followed was fair. That's the process. But it seems to me that if his complaint was that white executives were treated favorably, black executives were treated less favorably in relation to disciplinary matters. It went to the substance of the dismissal. You might be able to say yes, you might not be able to say yes, but I'm just putting to you what it looks like. The reference to process might be a wrong terminology.
The reference to process.
Yes, because it's not about whether he was given a reasonable notice as to when the disciplinary hearing will start. It's not about whether he was given enough time to give his evidence at the hearing. It's not about whether he was given enough time to cross-examine witnesses who were implicating him. It's not about whether he was allowed to call witnesses. It's not about that. It's simply to say you are treating black executives less favorably compared to white executives when it comes to disciplinary matters.
Chairman, that's a good summary. Thank you.
Yes, okay, all right. Mr. Mybeck?
So he asked you then to look into the fairness of Mr. Gama's dismissal, correct?
That is correct.
Did you feel that you were at liberty to refuse that request?
Maybe not, because at times this could have been a shareholder instruction, but then that is why then I had to follow a certain process to try and address this fairness or unfairness.
Did you construe it as a shareholder instruction, yes or no?
I think it was.
Thank you.
But having said that, we need to understand a certain technicality, because he was not yet the minister end of October. I think he became minister 1st of November 2010, yes. But I construed it as a shareholder request.
Or he could have had another meeting with you if you wanted. All right. So now...
Sorry, 1 second, Mr. Mybeck. I had wanted to go back to the issue you have just touched upon, Mr. Mkwanazi. I wanted to ask you the question whether at the time you were meeting with him, your recollection is that you were meeting somebody who was Minister of Public Enterprises already, or is your recollection?
Yes.
Or is your recollection that
I was under that impression? Yes.
You were under that impression, but
yes.
Oh, okay, all right, okay. Thank you.
Let me take you, please, to Mr. Mpama's evidence. Could you turn to bundle 3?
Okay.
And turn up page 30.
Page 30. Yes, I am on page 30.
When you met with Minister Gigaba or in that October meeting, Mr. Mkwanazi, are you able to remember whether he may have said to you that he had had a meeting with Mr. Gama, or he had, or Mr. Gama had discussed with him his matter? Or is there something you can't remember?
I don't recall that.
Yes, okay, all right.
So I wanted just to take you to what Mr. Mpoma had to say at paragraph 8. He says, I mentioned in this regard that from the outset of my interactions with Mr. Mkwanazi, and we know that they were around the Public Protector report, he made it clear to me that he had been instructed to reinstate Mr. Gama and that he wanted to find a way to do so cleanly. Although I did not consider my place to ask him who had instructed him, I assumed that it must have been former President Zuma. Now, do you agree or disagree with this statement?
I disagree with this statement in terms of a few issues. The word instructed is too strong a word. The word that maybe would be appropriate would be to review the fairness of the Gama matter. And also the way to say that I assume that it must have been former President Zuma. It's his assumption.
Well, perhaps I can add to that. The chairperson asked him what words did you use that caused him to infer that? And he said that you said to him that it was an authority above the ministry.
No.
Or that the instruction came from higher up.
No. Even if he had said that, I didn't say that, and I don't name drop. Particularly President Zuma, please, I don't name drop that person because I've never met him, etc., etc. Yeah.
But, well, that bears out his version because you didn't name drop. He says you didn't. You didn't use the name. That's the point.
I did, yeah.
You understand?
I did it.
Yeah. How would Mr. Mpoma have got this so wrong? I mean, he's a lawyer. He's someone who you entrusted with responding to, seems to me, the most important piece of work that landed on your desk, literally immediately upon you becoming the chairperson. You went out, you sought his advice and assistance. You obviously thought of him highly. How does he get this wrong?
No, I got it completely wrong. He really got it completely wrong. I was close to Mr. Mapoma, by the way, let me admit that. Yeah.
Oh, well, he did say that as well, so that the two of you ended up being quite close. So he's right about that.
He's correct. You need to understand a funny environment when that board came in. We must have interacted as a board with Mr. Mapoma in a period of maybe 3 months on 40 to 50 legal matters.
Yes.
And on all of these, we kept on working with him and also requesting him to consult other lawyers to help us as a board to look into certain decisions. There were many, many matters. And what is interesting as well, for some reason, I don't have records of the January interactions that the board had with Mr. Mapoma.
Yes.
And of course, others as well are missing. Yeah.
Yes. Well, before Mr. Mybeck continues, I note that in paragraph 8, you didn't take issue with Mr. Mapoma's statement where he said, you said you wanted to find a way to do so cleanly. So you took issue with his use of the word instructed, and of course, his assumption that you had been instructed by President Zuma, former President Zuma. So you might have used that part of saying, I want to do this cleanly.
Let me indicate that the instruction was to review, not reinstate. And also, the word cleanly is almost like legally, looking to the legalities of the issues.
Yes. Oh, okay, so where he says, you said you wanted to do this cleanly, you have no problem with that as long as it is understood that cleanly refers to legally. Yes.
That's
okay.
correct.
Okay, all right. Mr. Mybeck.
Thank you. Mr. Mkwanazi, we've seen that there was a meeting with KPMG.
I'm sorry, Mr. Maybeck.
Yes.
I thought you were, I was watching whether you were going to take this up. Mr. Mkwanazi, just now, you also said what you were instructed to do was to review. So I think that we can accept that you are saying whatever it is you were to do, it was as a result of an instruction. Is that correct?
The review, yes.
Yes, okay. So your query is, it was not an instruction to reinstate Mr. Gama. It was an instruction to review his case.
That is correct.
Okay, all right. Thank you.
Mr. Mkwanazi, I just want to ask you, why did you not deal with this in your declaration? Because one of the questions you were asked to address was whether the settlement was influenced by any member of cabinet. Don't you think it would have been necessary for you to explain?
That is why I was indicating that there was a supplementary affidavit which I had prepared many weeks ago, and it was sitting with my legal advisor so that they review it and I submit it. I would have touched on those points there.
Well, let's just deal with that.
So I take it that, and you must tell me if I misunderstand your evidence, I take it that as you give evidence today, you are able to answer that question which was in the letter from the Commission by saying, yes, there was a member of cabinet who influenced the settlement.
I do want to submit I still want to submit a supplementary affidavit which covers some of the points that I know are glaringly not addressed.
Yes.
In terms of a memo I got on the 28th of July, if I recall.
Yes, no, I understand
I would like to do it. Yes.
No, I understand that part. I'm just basically putting to you the question that was in the letter. Is there a cabinet member who influenced the settlement?
Well,
no. Not to my knowledge, no.
Well, in fact, what you were asked, Mr. Mkwanazi, is whether there was any member of cabinet who played any role, directly or indirectly, in the matter being settled.
Oh, yes, yeah. Thank you, Mr. Maybeck.
Yeah, if you pose the question that way, then definitely Mr. Kikaba, in my interaction with him end of October, played a role that says, can you review this matter? But not necessarily the actual settlement agreement.
But then why did you not put that? I'm sorry.
No, I'm not. I don't have a question.
Why did you not put that in your declaration?
Yes, I do indicate that there's a supplementary affidavit coming.
No, but Mr. Mkwanazi, in your declaration, you answered that question in the negative. You can't get out of this by saying you're going to put up another affidavit.
In my declaration, I do indicate that I did meet Minister Kikaba on a certain date. And also in the declaration that you have, I did not address all the matters you raised in a memo of the 28th of July. I've got a draft, it's sitting with my lawyer right now.
Mr. Chairperson, I see that it is 1 o'clock, if this is a convenient time to break.
Yes, we'll take the lunch adjournment and we will resume at 2 o'clock. We adjourn.
Okay.
All right.
Mkwanazi, we will be starting now. Mr. Mkwanazi, we will be starting now. Mr. Mkwanazi, he just took off his headset. Mr. Mkwanazi, he's not listening at all. He's taken off the headset. Mr. Mkwanazi?
Okay, thank you, sir. We're ready. Well, the judge keeps time.
Continue.
Thank you, Mr. Chairman. Mr. Mkwanazi?
Advocate, I'm there.
Yeah, good. Just before lunch, I was about to ask you, we've established that KPMG were approached on the 11th of January 2011. Can you remember?
Which bundle is it?
No, it's not in any bundle. It's something we've been over. You'll remember that their engagement letter reflects that they were first approached on the 11th of January 2011.
That is correct.
What I just wanted to ask you is, did you approach Denise Rates and Mr. Sibugule at about the same time?
I think so. Right. Or just after, towards the end of the month.
Towards the end of what?
Of January.
So you say it was either at the same time or later in the month?
Later in the month, I think.
And how did you come to appoint Sibugule from Denise Rates?
Do not forget that besides the KPMG report, there were other reports that I was privileged to at the time that related to what you can call Transnet internal audit reports, one or two, which I may not have right now. Yes.
Do you feel that you've answered my question?
Can you repeat?
How did you come to appoint Mr. Sibugule of Denise Rates? Why did you go to him?
Let me explain it that when this matter started indicating that the matter must now go to the Transnet Bargaining Council, that was then, but I only appointed Sibugule fairly late in January, but that matter of this thing going to the Transnet Bargaining Council was already there as early as 2010, September or October, yes.
Mr. Mkwanazi, really what I'm getting at is this. There are hundreds of attorneys in Johannesburg. How did you come to appoint Mr. Sibugule of Denise Rates?
I must have been advised by Mr. Mapoma because I'm aware that he was running with a big panel of lawyers that can do work at Transnet.
So you must have been advised by Mr. Mpoma.
That's correct. That is correct.
Well, are you sure that you weren't advised by Mr. Mklangu, the special advisor to Minister Gigaba?
It could have been as well, but I don't recall. because my linkages on legal issues were always with Mr. Mapoma.
Well, let me then take you, please, to bundle 1.
Bundle 1, yes.
Page 170.
Page 170.
The affidavit starts at 169.
Yes.
You know Mr.
Yes.
Mkwangu.
Yes, I know Mr. Mashango.
You knew him as the special advisor to
To the
Minister
minister.
Gigaba.
That's correct.
He says at page 170, paragraph 7,
Yes.
due to the passage of time, I can't recall the exact reason for or context of my discussion with Mkwanazi. He conferred with me on a variety of matters in my capacity as special advisor to the minister and in his capacity as chairperson of Transnet on things that he needed me to convey to the minister informally or prior to any formal process. I recall that during my conversation with Mkwanazi, I advised that it was prudent for Transnet to seek legal advice on the company's proposed course of action. We discussed a few options on eminent labor lawyers that he could consult. One of the names that came up is that of Mr. Sabugule, who at the time was a partner or director at Denise Rates, now Norton Rose. I offered suggestions because of my familiarity with the legal profession. It all remained with the chairman on how he intended to proceed. Do you recall that discussion?
I think it could have happened. That's correct, yeah.
So what we have here is the minister, as you put it, instructing you to undertake a review of Mr. Gama's case, and you then land up with the attorney suggested to you by the minister's special advisor, correct?
That is correct.
Now, what I want to then take you to is the chain of communication between the special advisor and Mr. Gigaba. Can you please turn to page 178?
Of the same bundle?
Of the same bundle, Mr. Chairperson.
Yes, 178.
So this is an email from Mr. Mkwangu to Minister
Yes.
Gigaba. And the second bullet point says, and that email, Mr. Mkwanazi, you would have seen is dated as early as the 18th of January.
Yes.
The second bullet point says, I understand that Transnet may be nearing a settlement with Gama. I will obtain the details of the settlement and brief you accordingly. I suggest that you socialize the president and his key aides, in brackets formal and informal, close brackets, on the proposed settlement. It is intended that the forthcoming board should consider and authorize it. So,
I see that statement.
So you were nearing settlement, were you? As early as the 18th of January?
I wouldn't call it settlement because first I would have had to go through a review.
I'm sorry, Mr. Mybeck.
Okay.
My attention was on some other page in another bundle. Just remind me the page on this
The page
bundle.
is 178, Mr. Chairperson.
178
Of bundle 1.
yes.
It's the second bullet point. This special advisor, Mr. Mkwanazi, reports to his boss, the minister, that he understands that Transnet is nearing a settlement with Gama on the 18th of January.
I'm sorry.
I
When you
see
said
what is written, yes.
I'm sorry, you said you read from what bullet point? Or?
The second bullet point.
Oh, okay, thank you.
Mr. Mkwanazi,
Yes.
this is a very troubling
I'm there.
email.
I'm there.
Yeah. Yes, I know. I want you to answer to what he says.
No, that statement is taking the matter ahead of where it was.
But where would he have heard this
The matter
from?
was maybe a week away from that date, because the matter had to be dealt with by Dennis Reeds and Mapoma in terms of my understanding of what I was trying to do, or what the instruction might have been to review.
But Mr. Mkwanazi, Mr. Mklangu says that he had conversations and discussions with you. Where would he have got this from? If he didn't get it from you,
He would have got it from me that the matter is going to be looked into by the firm and also by Mr. Mapoma and the board.
so he falsely reports to the minister.
Yeah, but that's premature in my interpretation.
Yes, but it's a false report that he makes to the minister.
To a certain extent, as it stands here, it's premature. He could have said that towards the end of January after I had interacted with the external legal advice.
Well, if it's premature, then it's false, correct?
It is false.
Yeah. Mr. Mklangu will come and give evidence on Monday, and then we will see what he has to say. But certainly on the face of it, what he reports to the minister is that you've already decided, haven't you, to reinstate
No,
or
we
settle with
haven't.
Mr. Gama, even before you had approached your board, correct?
No, we hadn't decided.
I see.
Well, when you say that what Mr. Matlangu says in that second bullet point was premature, are you saying that what he says was the position at that time was not the position? Or are you saying it may have been the position or was the position, but that was not the right time for him to start telling the minister about it?
Don't forget, even though we could have discussed a law firm, I could only do a law firm issue through Mr. Mapoma, and we only met with that law firm. And I briefed that law firm, if I'm not mistaken, after that date. So that's why I say his conclusion is seriously premature.
But, Mr. Mkwanazi, how could he just say to his minister, who is Minister of Public Enterprises, and to the extent that you say the minister, Mr. Kigaba, had instructed you to review Mr. Gama's case, to the extent that that is so, or maybe so, then it would be likely that Mr. Matlangu would know about that. Now, if he then reports to his minister on the 18th of January that he understood that Transnet was nearing a settlement with Mr. Gama, well, and if that was not the position, why would he just decide to tell his minister something that he had no basis for? What would be his interest in telling the minister that he understood that a settlement was looming, if actually
No.
that was not his
I'm not
understanding?
sure. Chairman, I don't understand what Mahlangu was indicating. Yes, he did suggest the law firms, Bule, and then I interacted with Mapoma because I don't deal with law firm issues. And a meeting was then set up between myself, Mapoma, and that law firm to try and address this minister's instruction of, was this process unfair? So yes, I did meet Spukule, but at a later date than that.
Yes, and Mr. Mahlangu himself, had you had a discussion with him before this date about the Gamma matter, whether in a meeting or in a telephone conversation?
It could have been in a telephone, because I got the recommendation of Spukule as a specialist lawyer, because already I was asking around. So it could have been a few weeks before, and then he suggested Spukule. And through that, Mr. Mapoma and myself approached Spukule and we discussed the matter. But that was far later than the 18th of January.
Yes, but what I'm talking about, prior to the 18th of January, had you had any discussion with Mr. Mahlangu, whether in a meeting or in a telephone conversation about the Gamma matter?
I might have, because you need to understand the funny dynamic with these special advisors. They phone you anytime.
Yes. Yeah. Okay. Did he phone you quite regularly, Mr. Mahlangu, by any chance?
He did. He did, yeah.
And would he ask about Mr. Gamma's matter sometimes? And
other matters, yes, it did.
Oh, okay, all right. Thank you. At the date of the 18th of January, that is the date on which he was writing to the minister.
Yeah, to his minister.
Do you recall whether you had done quite some homework on this Gamma matter? Remember, the minister had raised it with you for this first time in October of 2010. We are now about mid-January. Do you recall whether you had done quite some work to try and understand what the issues were and to form a view one way or another as to whether this unfairness that the minister was talking about in October might be well-founded or not?
Chairman, it's not what you would call legal work.
Yes.
It was requesting information in the organization, yes, about certain matters of procurement relating to what you can call not following processes of proper procurement. And there were a couple of reports already in the organization. Mm-hmm. One was a 2008 report, and there could have been another report, which were addressing these procurement irregularities.
Mm. Which, you talk about reports that you had asked for and had reached you.
I asked for inside the organization, and I did get at the time.
Yes.
And yes, I did have some reports.
And by that time, you would have read some of them? Some of those reports?
Not in detail, because they were fairly thick reports, on average maybe 100 pages each, and done by Transnet internal audit. So they were fairly detailed, but they did articulate what you can call procurement irregularities that had taken place, not just the one report I recalled spoke to 2008 or was published in 2008.
Yeah.
And the other could have been another report, but I've asked for those reports, funny enough, recently, and nobody's giving me that report.
Yes. So do you recall whether by mid-January you might have formed a view on your own on whether there was some unfairness on Mr. Gama's dismissal, even if that was not based on legal advice, just for your own sense of fairness? Do you remember whether you might have got to that point or not?
On the dismissal matter, as I indicate somewhere, I didn't see any unfairness.
Oh,
But
okay.
what I was looking for was were there similar things done in the organization. That's why that report on which talks to Transnet procurement, the title is Irregular Transnet Procurement of a certain time period.
Okay.
So it was more on the irregular procurement issues,
Okay, okay.
not on the unfairness of the dismissal, etc., etc. Yeah.
Okay, all right. Mr. Meinberg?
Thank you. Mr. Mkwanazi, perhaps I can just ask you again. I mean, how is it possible that Mr. Matlangu could have just made this up? I mean, how? Very strange, right?
I'm not sure. Hopefully, he will answer. He's coming next week, and he will answer. But yes, he did advise me to talk to Sbukule, and I discussed that with Mr. Saks Maponya, and we met with Sbukule at a particular time, and we discussed various things with Sbukule.
Yes, you're very good at camouflaging and talking about things that are not related to my question. It would be very strange behavior, wouldn't it be, for a special advisor to make up something and report it to his minister? It would, wouldn't it? You agree?
Frankly, I can't talk for Mr. Matlangu.
Okay.
Yeah. But yes, we met regularly, we spoke over the phone.
That's fine. All right, let's move on to something else.
Just one sec before you move on, Mr. Meinberg. Mr. Mkwanazi, I asked you about 10 minutes ago about whether Mr. Matlangu did regularly call you and whether
Yes, he did.
he discussed Mr. Gama's matter, and you said yes, he did. Now, Mr. Mapoma gave evidence and said that Mr. Matlangu did also call him about the Gama matter, and
Yes.
he said he called him twice. He said in the first telephone conversation, he was not pressurizing him to do anything, but he was inquiring about progress in the Gama matter.
Yeah.
But he says when he called him for the second time, Mr. Matlangu was definitely putting pressure on him, saying that Transnet was delaying, or he, Mr. Matlangu, was delaying the reinstatement of Mr. Gama or the settlement, I'm not sure, but he said he put pressure on him, and he had to be firm with him and tell him that he must stop doing that. He was not reporting to him or the minister, and he says he reported this to you, I don't know whether the following morning, because he suspected that Mr. Matlangu might tell the minister and the minister might call you. Do you recall him having mentioned, having received any calls from Mr. Matlangu about the Gama matter?
Yes, in terms of advice, which legal firm to look into as one of the legal firms, which advice I then discussed with Mr. Mapoma. And Mapoma then set up a meeting for me to meet Dennis Reeds or something. Yes. But I don't recall Mr. Matlangu giving me feedback that he had spoken to Mr. Mapoma. I don't
No, not Mr. Matlangu. What my question was whether you have any recollection of Mr. Mapoma reporting to you or mentioning to you that Mr. Matlangu had called him about the Gama matter and trying to put pressure on him, and he had to talk firmly to him.
Mr. Mapoma might have said so. I don't recall.
Don't recall. Okay, all right.
No, but yes, I did speak to Mr. Mapoma virtually once every 2 days.
Yes.
In conversation.
Okay, all right. Thank you, Mr. Mybeck.
What I then wanted to move on to, so this is on the 18th of January. Let's move
Yes.
to the 21st of January. And could I ask you please to go to file 3?
File.
File 3,
Okay.
page 105.
Bundle 3. Okay. I've got it. What page?
105.
Okay, I've got it.
So you see towards the foot of the page, it's an email from Mr. Selinga to Mr. Todd at Birmingham Philip.
Yeah.
You see that?
Yes.
And in summary, what Mr. Todd is told, if you go over the page at 106,
Sorry. Page here. Thank you, Mr. Mybeck.
at page 106, says, I confirm that the acting group chief executive and chairperson of the board, chairman of the board, I beg your pardon, of Transnet, Mr. Mkwanazi, has instructed as follows. One, that any sale and execution of the shares or any property belonging to Mr. Gama attached pursuant to the aforementioned warrant of execution be cancelled forthwith. That was the warrant of execution for the costs in the High Court. And two, that the shares or any property attached pursuant to the aforesaid warrant of execution be immediately released from judicial attachment. Three, that the warrant of execution issued in this matter be held in abeyance until further instructions. And then under that, regarding Mr. Gama's appeal, which is really the bargaining council arbitration, against the decision of the disciplinary hearing, that is set down for hearing before the bargaining council on Monday the 24th. Your instructions are to postpone the matter sine die, to allow negotiations between the parties to run their course. Do you see that?
Yes, I see that.
So here, on Friday the 21st of January, you put a halt to Transnet recovering its costs in terms of a High Court order. Why?
I did instruct Selinga in view of the fact that I wanted to entertain this meeting with this other company to look at the matter of this unfairness that was raised by the shareholder. That's why I did, just to put a stop into it until Dennis Reeds and others have looked into this matter.
But Mr. Mkwanazi, the High Court litigation preceded the disciplinary hearing and the dismissal. And there was a court order which was being executed in favor of Transnet. Why on earth would you want to become involved in that and put a stop to that? It's money that was owed to Transnet.
Yes, I did, but I wanted to exploit almost the shareholder instruction of, is this unfair, etc. And in view of time, I had not yet met Dennis Reeds to look into that matter. Yes, I did request that.
So you did this, if I understand your evidence correctly, in acquitting yourself of the shareholder instruction. That's what you've said, correct?
Can you repeat?
You've said that you put a stop to this, and in so doing, you acquitted yourself of the shareholder instruction.
To review the unfairness or fairness of that process. Yes.
But the shareholder instruction related to Mr. Gama's dismissal at a disciplinary hearing, this is High Court proceeding that were engaged in a year before, where Mr. Gama lost comprehensively and then sought leave to appeal, and that was refused. But somehow you found it to be your place to put this on hold.
I did put it on hold, yes.
Did you consult with your board, or did you feel comfortable in taking this decision?
I felt comfortable in taking this decision. I did not consult with the board on that.
So, and you also then put a stop to the arbitration, which was going to happen on the Monday, the 24th.
To postpone, yes, it's not put a stop, to postpone so that I review this request of unfairness or whatever it was.
But
yes.
What I don't understand is a professional body was going to undertake an arbitration and rule on that very question within a few days. Why didn't you just allow that to happen?
I needed to be satisfied in addressing what I called that shareholder request of looking into the unfairness of that process.
But Mr. Mkwanazi, if it was unfair, then the arbitrator would have ruled on that.
Yes, there was this new request,
Yeah.
which was saying, please look into the unfairness or fairness of this process. Now, in order to do that, I've got to consult some legal opinion of firm. And unfortunately, the calendar of events are such that my consultation could only take place towards the end of the month. So that's why I had to request that they stop these other processes until I have consulted Dennis Reeds.
I see. All right. Well, that was on the Friday, and we can see that you were busy because on the Saturday, you then engaged in a negotiation with Mr. Gama, didn't you? You wasted little time.
Maybe before that, Mr. Maybeck, can I just go back to the issue of stopping the execution? Mr. Mkwanazi,
Chairman.
The process that you instructed Bowman Gilfillan attorneys to stop, that is the process of recovering from Mr. Gama legal costs that the High Court had ordered him to pay to Transnet. That process could not possibly have anything to do with whether Mr. Gama's dismissal was fair or not. That was that order, which was made in favor of Transnet by a High Court judge, was an order made because the High Court concluded that when Mr. Gama launched an application to the High Court seeking a certain order against Transnet and the directors, he had no proper grounds, he had no case. That's why the High Court dismissed his application and ordered him to pay costs in favor of Transnet and its directors. So that was an application which happened before the disciplinary hearing began. So I can't see how it could have had any bearing on whether his dismissal was fair or not. Are you able to see that it could have had some bearing?
Chairman, I understand what you're saying.
Yes.
But then from my looking at the Gama matter and maybe looking at some elements of his contract of employment, I don't know if the issues are linked, but yes, I understand your
Yes.
your interpretation of the court judgment.
Yes, yes. Of course, maybe in your favor, I can say that at this stage, we are talking about what seems to have been an instruction to temporarily stop that process. So that might, well, maybe up to a certain level, one can understand if you said, until I understand what's going on, maybe let it stop. But when you later on then don't say continue, that's what we'll deal with in due course. Mr. Mybeck.
Thank you. So that's the Friday. Let's go to the Saturday. Could I ask you please to turn to bundle 2?
Excuse me, Chair, before then, if we may, can you indulge us, Chair, with a 5-minute comfort break, just to help ourselves?
Yeah, the reception is very poor when you speak, Mr. Mkwanazi, the lawyer.
I see, Chair. Apologies for that. It must be the connectivity. I was just asking for a 5-minute comfort break, Chair, if you may.
Yeah, I can't hear. I hear you asking for something, but I don't hear what it is you are asking for.
Chair, I'm not sure. Yes, Chair, I'm not sure what the issue is, Chair, but I was asking for a 5-minute indulgence, Chair, for a comfort break, if possible.
Were you asking for a break? A break?
5-minute comfort break, Chair. Yes, please.
Oh, okay, all right. Okay, Mr. Mybeck?
Certainly.
Let's take a 5 minutes break. Okay, we'll take a 5 minutes adjournment. We adjourn.
Thank you so much, Chair. Thank you so much, Chair. Much appreciated. Thank you.
These guys are doing a very good job. They do.
Are we ready?
Okay, all rise.
Okay. I take it Mr. Mkwanazi, the lawyer, is back as well.
Yeah, here, Chair. Thank you.
Is your counsel back, Mr. Mkwanazi?
Yes, Chair.
He is here, Chair.
Oh,
Yes.
okay, all right.
Thank you
Okay,
for the indulgence, Chair.
okay, all right. Let's continue then.
Thank you, Mr. Chairman. Mr. Mkwanazi, are you at page 3 of bundle 2?
Wait, bundle 2. Okay, let me go back. Page 3, bundle 2. Yeah, I think this is the one. Yes. Yes, I'm there.
So this is a consultation note of your attorneys
Yes.
of a meeting held at 9 o'clock on Saturday, the 22nd of January.
Yes.
Paragraph 2 says Temba Langa and Siyabonga Gama were also in attendance, but we initially had a caucus meeting between Sabu, Mr. Mpoma, Mr. Mkwanazi, and myself. Myself being Sabu Sangoni. You recall attending this meeting?
Yes, I do.
The next paragraph says, during the course of that discussion, Mr. Mpoma confirmed that the proposal that had been made from the company, which had been rejected, still stands. There's no counter proposal. So even by this time, the 22nd of January, already a proposal had been made. Is that right?
I think so.
Yeah. Well, maybe Mr. Mklangu wasn't wrong with what he said to the minister on the 18th of January.
He was ahead of himself.
I see.
Yeah, on the 18th of January.
Well, when was the first proposal made?
Yeah, I don't recall.
Sorry?
I do not recall. I do not recall.
Well, it would have been before Saturday, the 22nd of January. Correct?
It looks like it would have been, but truly I do not recall. Yeah.
I see. And what was the first proposal?
I do not recall.
Sorry, just so I understand it, you were the lead negotiator in these negotiations.
I was the lead negotiator.
Right,
Yes.
so you can't tell us what your opening gambit was.
I do not recall. No,
All right.
I do not recall. Yeah.
So let's go to the next paragraph then, Mr. Mkwanazi. Mr. Mkwanazi explained that he would like to assist Mr. Gama where reasonably possible. You see that?
Yes, I see that.
Why would you want to do that?
My assumption was that, again, based on what I called the shareholder review, was there any unfairness in the Gama matter? Yes.
But why would you want to assist the man where reasonably possible? This is Mr. Mkwanazi, this is a chief executive of Transnet Freight Rail that had been fired, and his arbitration was supposed to have been the forthcoming Monday. You have a meeting with him on the Saturday and you tell him, I want to assist you where, or you say to your lawyers that you want to assist Mr. Gama where reasonably possible. Why?
Don't forget, yes, I did indicate that, because also deep down in me, there was an element of doubt on a fairness, not of the sanction, not of the guilt or not guilt, that is fair, but of the sanction, in view of the fact that by that time, if I recall, unfortunately these reports are still not available, there were many other cases where similar procurement irregularities were not even investigated. Some they didn't even bother to apply for condonation. So that's the issue, the angle I was coming from.
I see. Well, we're going to come to your description, as you put it in inverted commas, similar irregularities in a moment. But let's go on to see what you say. So you say, yeah, there was information out there, and that was your point of departure, but then you say, what's reported, his intention, that being yours, is to bring him back into the chairman's office. He wants Mr. Gama to assist him in a number of strategic issues. Did you say that?
Yeah, I think I did.
All right, and then you say, he however needs a good motivation to do so. Did you say that?
I did, yeah.
And then it says, his view is that if he is provided with an opinion setting out that there was some unfairness towards Mr. Gama, at the board meeting on 16 February, he would persuade the other members to make a decision to bring him back into the organization.
That is correct.
That is an astonishing statement to make. Give me an opinion that shows some unfairness, and I will use that to persuade my fellow board members on 16 February to bring him back. You said that.
Yes, I did.
That suggests, Mr. Mkwanazi, that at that time you had come to the conclusion that if at all possible, you'd like to bring Mr. Gama back to Transnet. Is that a fair comment to say that that looks like that was your attitude?
That was my attitude, which needed support from a legal perspective, that these were the unfairness, not the dismissal issue, but the unfairness of the whole process of other executives not even being warned. Things just happened and things were forgotten for years and years on end.
So you did not think that he had been unfairly found guilty of the acts of misconduct of which he was found guilty. You had no problem with that.
The process was extremely fair. I don't have a problem.
The process was also fair.
Yes.
On the facts in relation to the charges of which he was found guilty, is the position that you accepted that dismissal was appropriate? The only thing that made you to want to bring him back was simply these other cases of other people? Or is the position that you thought that the sanction of dismissal, given the acts of misconduct of which he had been found guilty, was too harsh, irrespective of what had happened to other people? Or is the position that had there been no such other cases that you are talking about, you would have had no problem with the sanction of dismissal for an executive found guilty of this?
I agree with you fully, Chairman. It's a strange situation in that here's this individual. I don't know how many managers were there. Maybe at the time, maybe 2,000 managers, who a few others like him have done similar things, not even a warning for years and years. And then here comes this individual who does something similar to what other managers have done. And this particular, it was a question of consistency in that my interpretation was in that organization, there was no consistency at the time. Had there been similar cases which had been handled the same way as the Gama matter was handled, I would have had no problem whatsoever.
Yes. So, save for these other cases, you were comfortable that Mr. Gama's sanction of dismissal was fair?
From the individual handling of the matter.
Yes.
It was fair.
Yeah. Okay, Mr. Mybeck.
I'm going to come to what you keep saying, similar cases, but you said now, if there were similar cases to Mr. Gama, I would have had no problem at all. Remember saying that? You remember just saying that now?
Yes, I do.
Right. Well, let me give you an example of two.
But let me...
Sorry, Mr. Mkwanazi, please let me finish. Two cases that were similar were Sanamela and Kanye. You needn't look around.
You remember the two employees who worked under Mr. Gama who were dismissed? Yes, we talked about them earlier.
No, I do remember. But now, that's why at some stage, I would like the Commission to call in KPMG and Konki to present the report that I saw, because in that report, there's close to 22 other individuals where nothing was done. I do agree that those other two individuals were dismissed. I agree. But I'm saying, what about the other 22 or more who were not dismissed or even a warning given against?
But Mr. Mybeck asked you earlier before lunch the question, if you saw that some of the employees had been dismissed, just like Mr. Gama, but you realized that there were others who had not been dismissed, why is it that your attitude was not to say, then the others, the ones who were not dismissed, should also be dismissed, because it's wrong that they were not dismissed for such a thing? Why was your attitude that we must condone these serious acts of misconduct and allow Mr. Gama back?
Chairman, I did make a few examples of these big condonements. One was an increase in contract price from 980 million to 1.8 billion.
I'm sorry, Mr. Mkwanazi, I'm sorry. I think my use of the word condone is going to confuse you. Let me rephrase my question. Mr. Mybeck's question before lunch, one of his questions was, if you realize that in some cases, dismissals had been effected, but in others, no dismissals had happened. And indeed, I think you say in some, not even a warning. But in Mr. Gama's case, there was a dismissal. And there were some where there may have been a dismissal. Why didn't you say what is wrong here is Transnet's failure to dismiss these other employees? That is what is wrong. What is wrong is not its dismissal of Mr. Gama. What is wrong is its failure to dismiss the others, because what they were guilty of was serious.
Chairman, I can't fault your argument. You are correct.
Mr. Mayberg?
Yes, thank you. Mr. Chairman, could you please, Mr. Mkwanazi, go over the page to page 4. And there at paragraph 5 at the top, it's recorded that he, being you, was to discuss the details of such return to Transnet with Mr. Gama in a one-on-one meeting to be held between them. Now we see that there's reference on more than one occasion to you holding one-on-one meetings. Why did you not have other people present at meetings, negotiations with Mr. Gama?
Let me indicate that, yes, there were these one-on-ones. For some reason, unknown to me, Mr. Gama was not comfortable to be in meetings with other people except myself. And of course, even in those one-on-one meetings, me and Mr. Gama didn't agree on a lot of issues.
So you go on to say in that paragraph, there are details, however, that he's unfamiliar with, such as when Mr. Gama was fired, when Mr. Gama was suspended and the like. You didn't even know that. Correct?
Chairman, let me, you know, at times when you start a meeting, you want some background information from the people who are presenting the information to you. So it was part of that. I knew what has happened, but almost like sketch the background of this situation to me.
But Mr. Mkwanazi, you paint a picture that you had actually considered this matter. You were about to reinstate the man, yet you didn't even know when he had been fired or suspended.
I had a good idea.
Well, it didn't matter, did it really? Because you were going to reinstate him no matter what. You smile.
Not really.
Now, tell me,
Not really. Yeah.
What's not included there? You don't ask the question, what was he dismissed for? Did you know what Mr. Gama was dismissed for?
Yes, Advocate Chairman, I knew.
Well, explain to us, please.
It's the GNS contract.
Yes.
Where he exceeded his authority in terms of confining this thing to GNS when it should have gone out on open tender. And also he exceeded his delegated authority on such matters. If I recall, his authority allowed him to only contract up to 10 million. And if I recall, that contract went close to 90 million. By the time it was terminated. Then the other matter was the 50 new locomotives, where a board decision was taken that the refurbishment of these 50 new locomotives would be done by Transnet Engineering. And then he and I don't know who else decided that it would be done by an outside company, which somehow, from where I sit, it introduces fruitless and wasteful expenditure because that company must then set itself up when Transnet Engineering has got all the infrastructure to handle the refurbishment of the 50 light units. Those were the two key issues. And of course, the third one was this issue of attacking his colleagues. Now, let me just continue a little bit. If this was an isolated case and all other cases in the company were handled in a similar fashion, I would have dismissed him as well.
I see. So you had other cases where a CEO had besmirched the board of Transnet?
No, not really.
I see. When you say not really,
not really,
had you had any?
No, when I say other cases, not related to the gravity of the offense, but just related to the fact that he exceeded, he'd done a lot of irregular things in those two things. Now, I'm saying if it was a norm at Transnet to discipline people in that fashion, not the two, Sinamela and the other, all the others from, say, 2005, to discipline them, to get rid of them, to do whatever, I would have had no problem of Gama being dismissed.
But Mr. Mkwanazi, what about the third charge, which had nothing to do with tender irregularities, contractual irregularities, and nothing to do with condonation? It's very serious, isn't it, the third charge, if you actually know what happened? I mean, you have had the benefit of listening to Mr. Todd.
No, I've got an idea about the third charge as well.
Yes, well, what is it?
He publicly started attacking other executives.
Yes?
Yes.
And you agree?
That is unacceptable.
I think, and the board, or...
And the board, that is unacceptable.
Well, I need to deal with that, if you don't mind, if you just give me a second.
Well, while Mr. Mybeck is looking for something, let me go back to an issue that he has dealt with. With regard to one-on-one meetings between yourself and Mr. Gama, how many such meetings did you have with Mr. Gama?
I wouldn't know. We might have to ask Mr. Mapoma, because whenever I would meet, I never met Mr. Gama alone outside of these meetings. So I'll have to ask Mr. Mapoma, because for some reason I would insist that Mr. Mapoma comes with me to such meetings. I don't know how many meetings we had.
Well, I had been under the impression when I read his statement that there had been two such occasions, but when he gave his evidence, he said no, there was only one, namely said the Inanda one, which I think is when Denise Rate's attorneys were also present. Is it your recollection also that you
then
only
that's
had
the
one?
meeting, yes. I wouldn't have met him, even socially, I wouldn't have met him.
Yes. Now, excuse me, when Mr. Mybeck asked you why you excluded other people from that meeting and met Mr. Gama alone, you say that it was Mr. Gama who had discomfort in meeting with you together with other people. Is that correct?
That is correct.
So he had asked that he wanted to meet you alone.
He did ask, and I did agree.
Did you ever ask him why he did not want even your lawyers to be present? I don't understand what should make him uncomfortable, because you have lawyers to advise you. He has got lawyers to advise you. If you are going to talk settlements, both of you need legal advice. So why should they not be present? Did you ask him?
I did not. No, I did not ask him. But what I sense, I'm now assuming, there was a lot of media leakage around the Transnet issues at that time. And what I suspect maybe he was trying to do was to limit the media leakage of some of these discussions.
Yes, but really, if you negotiate the settlements in a legal disputes that's happening in a public forum like a bargaining council, I'm not sure that you would be so concerned about that, because in any event, you hold your discussions until you sign. There is no settlement. I just find it strange that there was this one-on-one meeting, particularly when the attorneys were around and you needed advice. I take it he needed advice. His attorneys were around as well. I mean, what is it that was so secret that he wanted to talk about? That's my reaction.
I do not know, because even my feedback to those meetings were actually feedback on what could have been discussed or of what options are there, etc., etc.
Yes.
Yeah.
Yes. Well, maybe Mr. Mybeck is still going to ask you further about the content of the discussion, but I heard from Mr. Mapoma that you reported to him after that one-on-one meeting with Mr. Gama that the two of you could not reach agreement because Mr. Gama, instead of asking to be reinstated in the position from which he was dismissed, actually wanted you to agree that he would be appointed to the position of Group Chief Executive Officer of Transnet. Is that true?
I suspect that, let me check. I suspect that Mr. Mapoma might have got his facts wrong there, because that position of Transnet Group Chief Executive was a position where there was a parallel process to interview, etc., etc. So I suspect what Mr. Mapoma might have meant is the position of a Chief Executive Transnet Freight Rail. I suspect that is what he meant.
Well, no, I don't think he confused that, because when he gave evidence, he was clear. Because I even asked him, I said, but Mr. Gama had been dismissed from the position of CEO of TFR.
You did, Chair.
Yes, and he said yes, but he said, but Mr. Mkwanazi told me that the reason why they didn't agree was that he now wanted to be appointed as, or he used the word reinstated as Group Chief Executive Officer, and Mr. Mkwanazi said he rejected that. He wanted him to be reinstated to the position of CEO TFR, which is the position from which he had been dismissed. That's what he said.
Oh, Mr. Mapoma said that, and I suspect Mr. Gama might have said that, but clearly, Chairman, I could never agree to a position like that.
Yes.
I know in actual fact I was looking at agreeing to something lower, etc., etc.
Yes, yes. So is the position that you are not sure whether Mr. Gama made this demand to be appointed to, but you...
I agree, Chair, I'm not sure.
You are not sure, okay, all right.
But I would not have agreed to it, Chair.
Yes. About that you were clear.
No, Chairman, I couldn't.
Yes. Okay, Mr. Mybeck.
Yes, thank you. Mr. Mkwanazi, can I take you, please, back to bundle 4A, your affidavit, page 18. A, 18, 1A.
Yes, I'm on page 17, page 18. I'm on page 18, Chairman.
If you just bear with us for a second.
Okay, I'm just getting there. Yes, Mr. Mybeck.
So it's paragraph 9.4. You've already confirmed this, but I just want to pick up on what I said I needed to just look at carefully. You say at 9.4, I personally fully agree with the disciplinary processes and findings of the then Transnet board. Presumably you're talking about the findings of the disciplinary inquiry, correct?
That's correct.
So you fully agree. The only difficulty I have is that there was this common process in Transnet systems called condonation. That was your only problem, as you put it, correct?
That is correct.
Can I then ask you, please, to turn to bundle 3.
Bundle 3.
Yes. Page 88.
Sure, which one? No, this is bundle 1. This is... Okay, let's check. This is what bundle is it? Okay, this is bundle 2. This is bundle 3. Yes, I've got that.
Page 88?
Page
88.
88. Okay, got it. Okay. Check. Page 88. I'm on page 88.
You see the last third of the page, there's a paragraph number 60.
Yes.
Just above that, there's a quotation. This is the finding of the chairperson of the disciplinary hearing on the third charge, the besmirchment charge. And I want to take you 1, 2, 3, 4 lines down in the middle of the page. Are you with me? There's a sentence saying this charge.
I'm on page 88, above paragraph 60.
Yes, there's a quote. Let me read the whole paragraph.
Yeah, I see that line. I see that line, yes. This charge. Yes.
This charge, says the chairperson, you agree with this, goes to the heart of
This
Transnet.
charge.
This charge, being the third charge, goes
Yes.
to the heart of Transnet's loss of faith in Mr. Gama, and there can be no doubt that dismissal is the only appropriate penalty for Gama's conduct under this. It's actually the fourth charge. You agree with that?
I agree with that.
And it's got nothing to do, condemnation has no bearing on this. Correct?
I agree with that.
Well, then I don't understand on what possible basis you could have reinstated Mr. Gama. On your own version, you are agreeing that the only appropriate penalty for the fourth charge is dismissal. Your only problem is there's this thing called condemnation that has no bearing on this charge, Mr. Mkwanazi.
Advocate Maibeck, you're spot on. But there is it's a consequential thing
Well, I hope
in
so.
my interpretation.
Right?
It's a consequential thing that came about because of the first 2 main charges. But I agree with that sentiment.
But then why did you reinstate him? Because your only problem was condemnation.
In other words, Mr. Mkwanazi, what
Yes.
Mr. Maibeck is saying, when
Yes.
you were looking at this issue, you and the board, and you sought to rely on condonation, you
Yes.
said Mr. Gama was not afforded the opportunity of using condonation. That could only apply to the other charges, not this one. So, that being the case, you ought to have said, as the board, you see, this idea that Mr. Gama was not afforded the opportunity to use condonation is not good enough to justify reinstating him, because that ground only applies to 2 of the acts of misconduct of which he has been found guilty. It can't apply to this third one. And yet this third one is on its own so serious that dismissal is appropriate. Therefore, you as the board ought to have said, no, we can't find our way to reinstating Mr. Gama, because even if we were to use condonation, there is this other act of misconduct to which condonation does not apply, and it is an obstacle to us reinstating him. That is what Mr. Maibeck is putting to you. Why did you not adopt that approach?
Chairman, my interpretation of the 2 main charges, the GNS and the 50 like new, they then lead to this inappropriate behavior by this executive. And therefore, that's why my focus was on the first 2 key charges. And because if then the first 2 had been dealt with in a particular route, the third charge might not have arisen. That's where I come from.
I do have some questions, but I want to allow you, Mr. Mybeck, to take it further.
Well, Mr. Mkwanazi, you've agreed. Firstly, let me debunk this. There's not two main charges in this case. There are three. And you've agreed that the only appropriate penalty for the third charge, or it was actually the fourth charge, was dismissal. You've accepted that. And you've accepted that condonation has no bearing on that. I think you're driven to concede that the reinstatement of Mr. Gama, just on that basis, was a monumental failure of judgment on your part. Isn't that so?
On the last point, yes.
The reinstatement
on this unbecoming behavior.
The reinstatement of Mr. Gama was a monumental failure of judgment on your part, correct?
On the last matter, but on the other two matters, there is ground to indicate that there could have been grounds for a different view in terms of the fairness of the system in handling the 50 like new and the GNS contract. But on the matter of how he then dealt with the executives and the board, I agree. My board did not apply a lot of what you can call attention to that matter.
Well, sorry, that's being a bit generous. You applied zero attention because but Mr. Mkwanazi, let's call a spade, because you were acting on instructions. You just did what the shareholder minister told you to do. That can be the only possible explanation, because how else could you have just left out of account this critical fourth charge without having been grossly negligent in acquitting yourself of your duties? How?
I'm not sure if it's an oversight, Advocate Mybeck, that there was no focus on that third charge. It is
Would you simply accept, please, that you erred in reinstating Mr. Gama then?
Not fully, but in dealing with the third matter.
He should not have been reinstated.
Yeah.
He should not have been reinstated. Correct?
Advocate Mybeck, that's your view.
I'm asking you.
The question, don't forget now, that after taking legal advice from this firm, who then poked witnesses in our case at Transnet Bargaining Council, and we then had doubt as the board that we could actually win this matter at Transnet Bargaining Council. Therefore, we opted to settle.
Mr. Mkwanazi, which attorneys poked holes into your case in the Transnet Bargaining Council? Because Bowman Giffilen said you had a very strong case. I understand that Weber Wenzel said procedurally you had done everything properly. And I've seen a letter or letters from Denate's race who said in relation to whether the dismissal was fair or not, who say they also gave an opinion that this dismissal was fair. So which attorneys poked holes into your case that was going to arbitration?
They created doubt, Chairman. Maybe I used a strong way. It's the comprehensive Dennis Reid's legal opinion post the first summary one, which had been given to the board.
Yes, I think Mr. Mybeck might
Yes, okay.
take that further, but let me go back to this question. I'm concerned that you don't seem to be prepared to make the concession that I think Mr. Mybeck thought you would make, namely that the board should not have reinstated Mr. Gama. Is my understanding of your position correct? Namely, your stand is...
That is correct. My stand is that board applied its mind and it saw some elements of doubt that it would win at bargaining council and then took a decision to settle.
Okay, all right. Now, my difficulty with that evidence is this. Mr. Gama was found guilty of 3 acts of misconduct. And I think you and I agree that each one of those acts of misconduct were serious or was serious. I think we agree on that. I think previously you have agreed. Is that correct?
Yeah, that is correct.
Yes. You have also agreed or conceded to Mr. Mybeck that the charge relating to the attacks by Mr. Gama on the executives and the board was serious enough to deserve the sanction of dismissal on its own. You remember that? That you accepted that. Now, if you accept that, what it means is that the chairperson of the inquiry relied on 3 grounds to say Mr. Gama should be dismissed. Now, 2 of these grounds, namely the acts of misconduct, had something to do with procurement, which is where condonation may apply, okay? But this other one had nothing to do with procurement, and therefore condonation would not come in. Why would you and your board not say, but why must we reinstate Mr. Gama when there is this one ground, one conviction if you like, which on its own is sufficiently serious to justify the sanction of dismissal? Why must we take him back? Because we can't fault the chairperson of the disciplinary inquiry for having concluded that he should be dismissed, even if it was this act of misconduct alone. Why don't you adopt that approach? That's the approach I would have expected from a board or from somebody who says this 3rd charge or 4th charge that has got nothing to do with procurement is sufficiently or serious enough on its own to justify dismissal. So that's what my logic would say. So you would, I would go back to the minister, I would go back to Mr. Gama and say, you may have had a case on the basis of the 2 serious acts of misconduct that are connected with procurement. If those were the only acts of misconduct of which Mr. Gama was found guilty, maybe we could have done something. But the problem is that there's this 3rd one, which has got nothing to do with condonation and procurement. And in our view, it is sufficiently serious to justify dismissal. Therefore, we can't take him back on the basis of this third one. What do you say? Is that not logical?
Chairman, I understand where you come from. Now, if you take the issue a little bit back, that yes, there were 4 charges. Yes, the fourth one was this one of unbecoming behavior by the executive. But then if you look at it from a perspective that says, what created that charge are the first 2 charges which related to procurement. That's my argument of then saying, as you deal with those 2, maybe the other one falls away. That's my argument, yeah.
But
I agree with your analysis.
Yes, but Mr. Mkwanazi, maybe remotely you could apply that reasoning if you took the view that the board and the executives who were attacked by Mr. Gama had done something wrong. But at the time when you were dealing with this matter, you knew that even Mr. Gama had admitted that he had been properly found guilty of these acts of misconduct relating to procurement. Therefore, his attacks on the board and on the executives for pursuing him for misconduct was unjustified. That is the reasoning that I would have expected from you and the board, to say, once you realize that this other charge had nothing to do with procurement, you say, but he is admitting that he is guilty. So he was attacking these executives and the board for pursuing charges of misconduct against him, saying that this was part of an agenda. He has now admitted that there was no such. He has now admitted that he was guilty. They had proper grounds to pursue him. So actually the fact that by now he was admitting that he was guilty makes his attacks on them even more serious, because he is now admitting in effect that these people were doing their jobs. So therefore he should never have attacked them. Don't you agree with that reasoning?
I agree with your analysis, Chairman.
Yes. Okay, all right. Mr. Mybeck?
Thank you. I was at page 4
Of which bundle?
of bundle 2. You then said at paragraph 6,
Yes.
once you clear on those details,
Please wait for me, Mr.
Sorry.
Mybeck. Page 4 of bundle
bundle 2.
2.
You say,
I'm sorry, Mr. Mybeck. Just to maybe complete what we were discussing, Mr. Mkwanazi. On this reasoning that I was articulating to you, it would therefore seem to me that it would not have been right, and it was not right. It would not have been right to say we will reinstate Mr. Mkwanazi, Mr. Gama, nevertheless, because even though there is this charge of which he has been found guilty, which has got nothing to do with procurement. When you look at the situation in the way I'm articulating, it would seem to me that that should lead you to saying, no, but we can't really take him back, because the fact that he admits guilt doesn't mitigate the situation. It makes it worse, because he attacked people for doing their job and did so publicly. You understand?
Understand, Chairman?
Yes, okay, all right.
So, Mr. Mkwanazi, at page 4, paragraph 6, it's recorded that once he, that's you, is clear on those details about when he was fired, when he was suspended and the like, he,
Yes.
being you, can then formulate a proposal. And then if you drop down to paragraph 14 of the consultation note at the foot of the page, it would appear that Mr. Gama and Mr. Lange do not take issue with the fact that Mr. Gama is guilty of the complaints as charged. All they intend to challenge is the sanction that was imposed. That you knew, correct?
That is correct.
And then at page 5, paragraph 16, at that point the caucus ended so that Mr. Mkwanazi could meet alone with Mr. Gama.
On page 5.
Yes. So you could meet alone with him.
I see it.
Right.
I see that.
Now, I'd like to take you, please, to file or bundle 3
Yes.
and to page 107.
Page 107. I am there.
Now, Mr. Mkwanazi, I take it that you knew that Bowman Gilfillan were representing you and Transnet in the Gama litigation. You knew that.
Yes, I knew that. When,
I beg your pardon?
when you say in the Gama litigation,
Well, in the
this
Gama arbitration, as you call it, an appeal,
okay,
you knew that.
I'm not sure if I knew that.
Mr. Mkwanazi?
All I knew, yes.
You issued an
I
instruction
knew that Bowman Gilfillan
Yeah.
are representing us in this Transnet bargaining process.
bargaining
which,
council.
has kicked in.
Yeah.
Yes.
So, you understood
yes.
that Bowman Gilfillan were representing you in the Gama Gama dismissal arbitration, the one that was supposed to be held on Monday the 24th. You knew that.
I'm not sure if I knew that.
Well, that's astonishing. Who are you asking for help from?
From Bowman Gilfillan.
No, I'm saying when you're just gesticulating on the screen. Are you suggesting to this? Well, let's decide who's going to
No,
talk.
I'm on my own here. There are two sort of matters. If I recall, Bowman Gilfillan are representing us on the Transnet bargaining council matter of Ghana.
Yes.
Yes, they are.
Right. Okay. So that wasn't too difficult. And
Yes.
you know that they also represented you during the disciplinary hearing. You would have, even a little investigation would have shown that, correct?
Yes, that's correct.
And you knew that that disciplinary hearing, presumably, you would have come to learn, went on for a very long time.
That is correct, but don't forget that disciplinary hearing would have taken place maybe some 6 to 8 months before.
Yeah.
And I was not there then. And that's why my engagement with them starts in January when this matter is being prepared
Yes.
for the Transnet Bargaining Council process.
And you knew as well that Bowman Gilfillan had engaged a very preeminent senior counsel. Correct?
I don't know. Yeah, is it Mr. Todd?
You knew that the attorney was Mr. Todd.
That's correct.
You watched him on TV the whole of yesterday.
Yes, I saw him, yes.
Yes.
He's a good attorney. Good attorney.
So you knew that.
Yes.
So Mr. Todd from Bowman Gilfillan and his senior counsel were steeped in this case, correct? They had worked on it for a very long time, correct?
That's correct.
But you never so much as picked up the phone and asked Mr. Todd for his advice on your prospects of success, correct?
No, I did not.
I suppose why you didn't do so is quite obvious.
I don't know.
Well, why didn't you phone him?
It
Can I suggest to you why you didn't?
When you say it's quite obvious,
Well, let me tell you why you didn't. Because he would have told you that you were going to win the case. Correct?
I hear where you're coming from.
You didn't
Yes.
want to hear that, did you, Mr. Mkwanazi? Correct?
Not really. No.
Yes, well, precisely.
My interpretation of Bowman Gilfillan, by the way, I never saw their correspondence prior to maybe the beginning of January 2010. So yes, they would have been corresponding with my group legal, but from where I sat, I almost wanted a new pair of eyes to look into this matter as it gets into the Transnet Bargaining Council process.
So let's...
I don't understand that, Mr. Mkwanazi. Please help me understand that. I don't understand that. You come to an organization for purposes of being part of the board. You are new in this organization. I know that previously you had been, I think, group CEO and so on. So,
Correct.
but for purposes of being part of the board, you are new. You come at a time when there is a matter that the minister tells you about. On the first occasion he meets with you and offers you to the position of chairperson of the board. So it's obviously an important matter. And he instructs you to review it. That means you must go into it and see whether there was fairness or not, okay? Mm-hmm. Now, the organization has been using this particular law firm. This law firm has been handling this matter over the previous 2 years or so. From the disciplinary hearing, they had represented Transnet even in the High Court application, which they won. They succeeded. It means even in the disciplinary hearing, they represented Transnet successfully. They won because Mr. Gama was found guilty of 3 serious acts of misconduct and was dismissed. So these are attorneys, or this is a legal team which you must have got to know had won the High Court application for Transnet that Mr. Gama had brought against Transnet. 2, had won the disciplinary hearing, so that served your organization well. Now, you want to understand whether there was some unfairness. You don't want to talk to them. You just want to get another law firm? On what grounds? When they haven't said anything you don't like, they haven't performed anything badly. On the contrary, they've done very well for Transnet. But you don't want even to talk to them. You want to go to another law firm? I don't understand that.
Chairman, that's the decision we took at the time. And in my interpretation, we needed almost a different set of eyes. Yeah.
Why do you change a winning team? This is a winning team.
I remain saying that we needed a different pair of eyes on this matter. And yes, if Bugule or Dennis Rees or whatever they're called. Yeah.
Well, if you had had a discussion with this law firm, which had been so successful with this legal team, if you had had a discussion with them, and through the discussion, you felt that their advices maybe on some of the issues on which you sought advice were not satisfactory, I would understand wanting to say, let me hear somebody else. But I have difficulty understanding the logic where you have not even discussed with them, and yet they have been
Mr. Mkwanazi, you can hear me now?
Tell him to unmute, sorry.
Please unmute yourself, Mr. Mkwanazi.
There we go.
We are going to start again. Eh?
Okay.
Thank you.
Should be working.
All rise.
Okay.
Okay.
Thank you. Mr. Mkwanazi, I wanted to take you, please, to bundle 4, page 6, part of your declaration.
4. Okay. Page 6. Yes.
Now, you see that paragraph 6.1, you make reference there to KPMG and Nkonki. And then the next sentence says, the first report was done quickly as the information was historical. It is that first report that was used by the board in its deliberations. You see that?
Yes.
Now, could I ask you then to turn, please, to bundle 2.
Bundle 2.
And if you could turn up, please, page 380. These are pages that would have been inserted earlier today.
380.
380.
Yes.
Are you there?
Yes.
So the Commission made a request for information on KPMG and then issued a summons in order to obtain the various reports. And the reports that KPMG produced, we know they produced a final report in November. That's attached to your declaration. They produced 2 other reports. A progress report on the 24th of January, that you find at pages 380 running through to 400. And then they produced, and this is referred to in your letter to the public protectors we'll come to in a moment, they produced an interim report at page 401, dated the 26th of April 2011. So a progress report 24 January, an interim report 26 April, and then a final report in November.
Yes.
Now you say in your declaration that the first report was done quickly, and it is this report that was used by the board. Presumably, you must be referring to the report of 24 January.
I thought they had done a report by then, but looking at what I'm seeing here, it looks like it was not on the 24th of January.
Well, that's my very point.
Yes.
So what was the first report that was used by the board in its deliberations? Because this report wouldn't have helped it. It's a progress report that sets out the mechanics and the manner in which KPMG and Konki are going to set about their task?
My understanding, besides this report, there was another report on Transnet irregularities, which is dated 2008, which I had at the time.
Mr. Mkwanazi, I think you might be confusing yourself. The paragraph that
Yes.
I've read to you says that it was the first report of KPMG and Konki. We know that you instructed...
It's a long time ago, by the way, in terms of whatever we're talking about. It's now 9 years old.
Yes, that's true.
So, and I truly thought that this report here, by the way, I've never had this report. I only saw it today.
Well, so did I.
I thought that this report from page 401 was actually published before the end of January. Yes, I thought that.
Well, that's completely wrong. You refer to this report in your letter to the public protector, and that's in June.
Wait, to the first...
I'm sorry, Mr. Mkwanazi, I'm sorry. I think you are on the same page up to a certain point. And Mr. Mkwanazi, you must tell me if I misunderstand. I seem to understand you to say you concede that the board could not have had this interim report, which starts at page 401, could not have deliberated on that in making the decision whether to reinstate Mr. Gama.
I concede,
You
yes,
concede
because
that, yes.
I've never seen, I'm seeing this for the first time.
For the first time,
But
yes.
I was under the impression that there was a report towards the end of January 2011. And besides, there was another report from Transnet Internal Audit, which I had at the time, which spoke about the so-called 30 individuals who had done various things. But
Okay,
even that I don't have. Yeah.
Let's take it step by step. Okay, you concede that this is not the report that the board could have deliberated upon in making the decision to reinstate Mr. Gama. That is the interim report. You accept that your affidavit at page, at paragraph 6.1, talks about an interim report of KPMG, which might suggest it is this report, but you accept that what the affidavit says cannot be correct.
It's not correct.
Yes, okay, all right. Then, Mr. Maybeck, you want to take it from there?
Thank you. Then you talked about an internal audit report that you say you had. That's the one attached to your affidavit, correct? Is that what you're referring to?
There at all. It's called procurement irregularities at TCP, procurement irregularities at TFR, etc. It's a report around 2008. I still don't have that report.
Yes, but that wasn't before the board. So what we know then...
I had the report.
Yes.
I had the report then.
Mr. Mkwanazi, what we do agree upon is that as of the 16th of February, and we're going to come to that board meeting.
Yes.
The 16th of February, the board didn't have any report from KPMG stroke Nkonki.
That is correct.
All right.
I agree with you.
All right. Now I want
Did the board, as at the 16th of February, have any report before it at all which talked about how any employees had been dealt with in terms of deviations or non-compliance with procurement procedures?
There was a report. For some reason, it has disappeared, the one I'm talking to. its title could have been Transnet, Transnet irregularities by Transnet internal audit done in 2000. There were actually two reports, done in 2008, and then there was another report. Now, for whatever reason, those two reports are missing. And at the time, if you recall, there was this supply of a lot of information to my office by the organization. So I do recall having seen one or two of these reports.
Yes, now I understand your evidence insofar as it says you were aware of such reports, one or two, or you were in possession of such reports. But are you sure that those reports, or one of them, those reports were, or one of those reports was before the board at the meeting of the 16th of February?
My recollection, there was a report tabled to support certain statistics of allegations, condonements, etc., etc. I hope somebody could just unearth that report.
Do you recall whether, if there was such a report before the board, it did deal with the facts of those other cases in order to be able to compare like with like in regard to Mr. Gama? Because it can't be useful to just look at any case where there was non-compliance. Each case has to depend on its own merits, isn't it?
Chairman, you are correct. That report would not have listed these cases in comparison to Mr. Gama.
Yes.
But it would have listed similar irregularities, the quantum of the condonements, etc., etc. It was actually two reports without referring to Mr. Gama.
Yes. Okay, Mr. Maibe.
Well, we're lucky because we've got affidavits from many of your fellow directors, and we'll see in time what they say. But let us start with the board meeting of the 25th of January, just to follow the chronology. Could you please go to file 1?
File 1.
Or bundle 1. And to page 534.
Page 534.
534, that's part of the minute of a board meeting on the 25th of January 2011.
534.
And if you could please
534, okay.
go to paragraph 4.1.6.
6.
There it says the chairman, which is you, stated that he was currently occupied with more than 30 cases with similar allegations to those levelled against Mr. Gama. He indicated that there was evidence that there's a culture of condonation of exceeding delegated authority within the company. So yes, that's what you said.
That is correct.
But you gave no documents to your fellow directors. You told them that, correct?
There was, that's why then also I find it interesting that I get this minute today. I've never heard it. That is why then I am keen to get, what date was this thing? Yeah, 25th. I am keen to actually get those reports by Transnet Group internal audit. It was 2 reports. And I do recall that I based my 30 cases or so, which were not identical to Gama's because those cases never dealt with arrogant behavior towards colleagues, etc. Those cases were dealing more with procurement issues.
Yes. But the point that I make, Mr. Mkwanazi, is that you didn't give your fellow directors any documents. You simply told them that you were occupied with these 30 cases, correct?
Hold it. On paragraph 414, there was this document,
Right?
procurement regulatory Transnet, there was another document as well. But it is this document that I thought the board had sight of, where now I was talking to this list of 30 similar cases, if I were to use the word.
All right, then could you please go to paragraph 418, because I want to come to an important meeting.
But not 100% similar.
418.
418. Yes.
The chairman assured the board that the company was cooperating fully with the public protector. He informed the board that he had a discussion with Mr. Gama on 22 January on a proposed settlement agreement. He had advised the board that the matter will be deliberated on at the Corporate Governance and Nominations Committee and then recommended to the board for approval on 16 February. So that was the route to the 16 February meeting. First, a meeting of the GCNC on the 3rd of February, correct?
That is correct.
So let us go then to that meeting.
Which meeting?
The meeting of the Corporate Governance and Nomination Committee on the 3rd of February. Sorry, before I do that, there's a few things I need to deal with. There was another board meeting after the 25th of January. It was on the 1st of February.
Yes. What is its page?
Let me just take you there. Sorry, if you just give me a second. Those minutes are at 916 of the same file.
Page 916.
Yes.
916, not 8916, I think. 916.
Yes, and then if you could go forward to 918.
Yes.
And if you have a look at paragraph 4.1.10 towards the top of the page,
yes,
the chairman stated that he was in settlement discussions with Mr. Gama. He stated that Mr. Gama was only appealing the sentence that was imposed. He added that the committee was currently reviewing Mr. Gama's sentence, and the proposed settlement agreement will be presented to the board for approval on 16 February 2011. Now, what committee are you referring to there?
It would be first, I suspect, the corporate governance.
Right. So that's on the 1st of February. Now we know that something very important happened on the 2nd of February. And that is Mr. Todd. Sorry, is there something you're reading?
Paragraph, what paragraph?
No, I'm not referring to any
Page
paragraph.
918.
I'm off that document, Mr. Mkwanazi. Perhaps you can just concentrate on my question, please.
Yes,
Okay.
1 second, Mr. Mybeck. Mr. Mkwanazi? Mr. Mybeck
Yes, Chairman.
just read from paragraph 4.1.10 or at page 918. But I think arising
Yes.
from that, he has a question for you, Mr.
Yes.
Mybeck.
My question was, what committee are you referring to there?
It would have been the corporate governance to then come back to the board.
Okay, thank you. So, Mr. Mkwanazi, that's on the 1st of February. I now want to move to the 2nd of February. I'm off that minute now.
Yes.
All right. On the 2nd of February, Mr. Todd produced his report. You've seen that report.
Yes.
Could we please go to bundle 3?
Bundle 3. I don't have this, the previous one. Oh, yeah. Okay. Bundle 3,
Page 60. Oh, beg your pardon.
bundle 3, page 16.
Page
Page 16.
65.
Oh, page 65, okay. Make a note of that bundle, of that meeting. 65 years.
I take it you received a copy of this report.
Yes, I think I did, yeah.
Well, what do you mean you think you did?
Yes, I did.
Right. So you'll see that it spans from 65 all the way through to 90. 25
Yes.
pages of report, correct?
Yes, that's correct.
Very comprehensive and detailed report.
Yes.
This also wasn't music to your ears because at this point in time, you were close to reinstating Mr. Gama, correct?
We were closed, yes.
Yeah. Did you ever read this report?
Yes, I did.
And what impression did you gain? Was this a report of a competent attorney? Someone who obviously
Yes, it
had a
was.
handle on the
It
matter?
was. It was.
Yeah. Was there anything missing from this report that you...
It's comprehensive.
It's all there.
Yes.
When you read this report, did it leave any room to conclude that you were going to actually lose the arbitration?
No, but then that did not stop me from getting a second opinion on
Yeah.
it, which is why then I approached the Beneservice.
Did you note that last paragraph, Mr. Mkwanazi, on page 90, namely paragraph page 90, same page?
Yes.
Paragraph 67.4, where Mr.
Yes.
Todd says there would have to be compelling reasons not to abide by the outcome of a properly constituted disciplinary inquiry and the outcome of the bargaining council arbitration mechanism that is prescribed by law to determine a dispute about the fairness of a dismissal. You
I
obviously
did
read that as well.
Yes.
You did.
Yes.
Having read that, would you accept that at least what this attorney was telling Transnet and the board was the outcome of the disciplinary inquiry is one that is fully justified, and to do anything to undo that, you would need very compelling reasons. Is that how you understood it?
That is correct.
Yes, okay, all right. Mr. Mybeck?
Yes, thank you. So that's on the 2nd of February. I now want to come to the meeting of the Corporate Governance and Nominations Committee on the 3rd of February.
What page?
I'd like you please to go back to bundle 1 and to turn up page 827.
One. Can you help me with bundle 1? Okay. Page 827. Yes, I see this.
Yeah, those are minutes of the meeting of the Corporate Governance and Nominations Committee on 3 February 2011.
Yes,
All right, now, Mr. Mkwanazi, you were the chairperson of that committee.
that is correct.
The other members were Ms. Nyaka, Ms. Chepe, and Mr. Sharma, correct?
That is correct.
And we see under partial attendance, Mr. Mpoma was present, correct?
That's correct.
Now, if you go to page 828 over the page, you'll see there's a heading.
Over the page.
You'll see
Page
there's a
828.
Yes, over the page, please.
Yes,
You see there's a heading, 6.7, report back from the advert process. I mean, what was happening here is the position, the vacant position of Transnet GCE was being advertised,
that is
correct?
Yes,
And you would accept that much of this meeting was dedicated to whether or not Mr. Gama should be allowed to put forward an application, or for his application
That
to
is
be
correct.
entertained.
yes,
If we could then please go to page 830.
yes,
And there at paragraph 6.9, about halfway down, investigation by the
Yes.
public protector, Mr. Mpoma took the committee through senior counsel's opinion that was obtained with regard to Mr. Gama's application for the GCE position. He highlighted that the legal opinion was based on the following three issues. Does the guilty verdict against Mr. Gama exclude him from being considered in the current GCE selection process underway? How does the pending appeal affect the board decision to interview or not? Does the public protector complaint currently being dealt with have a bearing on the selection process? You confirm that?
yes,
In the next subparagraph, Mr. Mpoma informed the committee that senior counsel's opinion was that Mr. Gama should not be excluded from the current GCE selection process. Ms. Chepe indicated that senior counsel's opinion was not the same as the lawyer's opinion. She stated that the general rule was that in terms of clause 4.8.4 of the company's recruitment procedure, the company may deviate from the policy if there are exceptional circumstances that warrant the deviation. You see that?
I see that.
And then I'm going to come back to that opinion and that clause. Mr. Mpoma further took the committee through the proposed settlement agreement between the company and Gama, stated that there was no agreement on the following issues: the date of reinstatement, the position to which Mr. Gama would be reinstated, etc. So, central to the business of this committee on the 3rd of February was this issue of clause 4.8.4 of the recruitment policy, correct?
That is correct.
Now, could I ask you, please, to now turn to bundle 2. Keep this bundle open where you are at file or bundle 1, but then open as well, please. Bundle 2.
Yes. Bundle 2, what page?
Let's go first to page 302.
302. Three 302. 302, yes.
Yes. Are you there?
Yes, I'm there.
So this is the recruitment and selection policy. And let me take you to, and no doubt you're familiar with this, let me take you please to clause 4.8.4 at page 307.
Yes.
Says at 483, just above that, when determining whether a person is suitably qualified for a job, steps must be taken to determine whether, and it sets it out, and then 484, the candidate must not have been previously dismissed from Transnet for reasons relating to incapacity or misconduct. Correct?
Yes.
And of course, the problem was that Mr. Gama had been dismissed for misconduct, right?
Yes.
And the issue that then arose before the committee is whether one could depart from 4.8.4 on the basis of clause 2. And clause 2 you find at page 304.
304.
304.
Yes, I see clause 2.
Under the heading Scope, this policy applies to all job applicants and employees of Transnet. Transnet may, however, at its sole discretion, deviate from the policy where necessary in respect of executive appointments. Now, that was really the debate. You remember that?
Yes. Yes, I do.
Now, Mr. Mpoma, in his report to the committee, as we've seen, spoke of a senior counsel's opinion. Let me take you to that opinion. You find that at page 293 of the same bundle.
Of the same,
of the same bundle.
293. I've got this, yes. 293, yes.
If we go to paragraph 13 at page 297.
I see it.
Council said, however, clause 2 of the recruitment procedure provides that Transnet may, at its sole discretion, deviate from the policy where necessary. The next paragraph, however, the discretion to deviate from clause 4.8.4 is not an unconstrained one. This discretion must be exercised after consideration of all the relevant circumstances. Furthermore, since Transnet is an organ of state, decisions taken by Transnet are exercises of public power and therefore need to comply with the minimum threshold of rationality. This requires a rational connection between the decision taken and the reasons given for it. See that? And then, if I could take you please to paragraph 19 over the page, 19. Are you there?
Yes, I'm there, but there's a problem with the system. It keeps dropping.
All right.
Can you listen as well, if you can? Yeah. Yes, I'm there. I'm on page, you said 297.
298.
298.
Paragraph 19.
I'm there. Yes.
Council said, a crucial fact to be taken into account in the exercise of this discretion is Mr. Gama's failure during the arbitration proceedings to challenge the findings of misconduct made against him by Entrobus SC. By not challenging these factual findings, Mr. Gama impliedly concedes that he was guilty of misconduct. It may well not be rational for Transnet to interview a candidate who has conceded to having misconducted himself in carrying out of his duties as chief executive. You see that? It may well not be rational.
I see that.
Correct?
Yes.
And would you agree with that?
Yes, I do.
Okay. So let's then have a look at the decision of your committee.
Okay, that's
and
file.
For that, we need to go back to bundle 1, yes.
Yes.
If I can please
page 830.
Direct your attention, yes, we've looked at 830, I'd like to go to 831.
There's a problem with sound.
Oh, can you hear me now?
Yeah.
Can you hear me now?
I can't hear Advocate Mabeka. I can hear the chairman.
Oh.
Well, I'm not speaking. Can you hear me?
Advocate, I can hear you.
All right. So let's go, please, to 831 and to paragraph 6.3.13. Are you there?
Yes. Yes, I'm there.
Deviation from clause 4.8.4. Ms. Chairper and Ms. Nyaka,
Yes.
Ms. Chairper and Ms. Nyaka stated that the current settlement negotiations with Mr. Gama were a rationale, presumably, for deviation from clause 484. Mr. Sharma disagreed and stated that it was not in the best interests of the organization to deviate. Mr. Sharma stated that he was unhappy with how Mr. Gama's matter was being handled. He indicated that he was of the view that the committee was not considering the best interests of the company, but that of an individual. The committee voted on whether it should deviate from clause 484. There were 3 votes against 1 in favor of deviation. So what we know, and then it was resolved, I beg your pardon, that the committee recommends that Mr. Gama be considered for the GCE selection process. So who voted in favor of deviation was you, Ms. Nyaka, and Mr. Shepe, and against it was Mr. Sharma.
Yes.
Is that right?
That's correct.
Now, does this minute reflect any consideration of the advice that you received from counsel that to interview someone who had admitted guilt?
It does not at face value, yes.
Right.
Yes.
It does not at face value.
Yes.
Is it something that you considered?
The advocate on the other side. No, I do concede that at face value it does not, but there was this subcommittee which was debating this matter.
Right.
And that subcommittee then took a certain view that this person can be allowed to be interviewed.
Yes, because of the settlement negotiations. Correct.
That's correct.
But there's just a consideration of the settlement negotiations. There's no consideration of the fact that it may not be rational to interview a candidate who has conceded to having misconducted himself in his capacity as a chief executive officer. I mean, it's a great irony. You're actually settling with that person, but no consideration is given to that, is it?
No, I agree with you, Advocate.
But you see, Mr. Mkwanazi, isn't this really the game? I mean, wasn't the truth of the position that former President Zuma still wanted Mr. Gama to be the chief executive of Transnet? And in order to allow him to throw his hat into the ring, the first thing you needed to do was to deviate from 4.8.4. And that is actually why you were settling with him. You were getting him back so he could go to this higher office. Isn't that actually the objective?
I would disagree with that simplicity.
Right.
Because you put it as if because President Zuma at some stage had wanted him in that top position. But this position at that current time, there was a headhunter who had been appointed to deal with the candidates who were keen to be considered for that position. So he would have competed with other candidates in terms of suitability. Yes, from clause 4.8.4, I understand fully what you're saying.
Well, I just can't understand how you could deviate from it in the circumstances of this matter.
We did deviate.
I see.
Well, you see, Mr. Mkwanazi, I mean, you did indicate that you were listening to Mr. Todd's evidence yesterday. So you know all the things that I was saying. And at some stage I did say that part of the reason why I was articulating some of the thoughts that were crossing my mind was precisely so that somebody like you who could be listening, who would still be coming to give evidence, could know what sort of issues were troubling me, so that when you come to testify, you know, you might have thought about them and can address them. So it's a transparent way of looking at issues. So you know what's going on in my mind. You can address it head on if you can, and if you can't, you can't. But I'm not hiding from you what is going on in my mind. So I have difficulty with I have serious difficulty with the whole idea of the board reinstating somebody who had occupied such a senior position in the organization and who had been found guilty of such serious acts of misconduct and was not challenging those findings, you know, accepted that they were correctly made, but with the board thinking of reinstating that person. But now, you are already here as this committee, are doing something that contemplates that this person could actually be promoted. I can't understand the logic unless there's something else. But in terms of the facts of the case, in terms of the process, fair process to which Mr. Gama had been subjected, and looking at the seriousness of his conduct, I'm looking at this committee and I'm saying, not only is this committee thinking of reinstating Mr. Gama, actually it's it seeks to give him a platform to go and occupy an even higher position despite the failures in his conduct. How is that possible? How is it possible that so many people, or the people in this committee and subsequently in the board, would think that this is correct? That's my thinking. You know, as I say, even yesterday and on other days, I say in the hearing what's going on in my mind, because I'm being transparent. If somebody wants to address it, they can address it and say, Chairperson, I see this is how you are thinking, but here is another angle from which you must look at it. Then I can look at it. But when it comes to this issue, I have this serious difficulty. What can you say to me about it?
Chairman, I fully understand where you are coming from. And yes, we did debate this clause 4.8.4. And yes, Mr. Sharma was not supportive, but yes, the other three board members, including myself, were supportive of Gama being interviewed.
Upon reflection, of course, you have had many years since this thing happened. Upon reflection, as you look at it now, look back, do you think it was the right thing for this committee to do?
Chairman, I would have followed the advice of Advocate Sebenza.
Yes. Okay, all right. Thank you.
But why didn't you follow it at the time? I mean, you asked for his advice.
No, we did ask for the advice at the time through debate and looking at various issues of debating that matter. I was of the view that he must be given that opportunity. But don't forget, it's now 9 years later or 10 years later. And then I'm asked the same question. And I'm saying, hold it, I might have a different view.
Well, perhaps you're not in the same position, and perhaps you're not as compromised as you might otherwise have been 10 years ago. Isn't that so?
I understand, Advocate, I understand.
All right. Well, let's then go to this debate. And I assume you watched Mr. Mphoma's evidence on television, because we're coming to that part of the transcript that he testified about. Would you please turn to page 854 of Bundle 1? 854.
854. Okay, I've got that.
And let me ask you to drop down to, you see on the left-hand side, there's numbering.
Yes.
There's a 685 towards the bottom. Can you just go up 2 lines from that? And you see Chairperson, who's yourself, you say, can you comment on that, the appeal process? You see that?
Yes, I see that.
And you're asking Mr. Mphoma to comment on that, correct?
Yes.
Okay. Then let's go over the page to 855. And Mr. Mphoma
Yes.
says he's not appealing against the finding of guilt, he's appealing against the dismissal. Now I said, you see that?
I see that.
Ms. Chairperson says, which is the disqualification? Sorry, Sachs. I just want to understand which is the disqualification. And then Mr. Mphoma says, right, now I advise the chair to say, if we as Transnet go to the appeal, that we know is the arbitration, and oppose the appeal, we stand a very good chance of winning that appeal. That was my view at the time. Where I'm saying we are not strong, Doris, is if we have to explain the rationality of why we are settling. I don't think we're on very strong grounds on that. That is my view, but on the disciplinary process itself, and if we go and argue the matter on appeal, we stand a very good chance of succeeding. SIA can win, but we can also win as Transnet. But we have a very, very good case against him there. That is why we said, let's rather postpone to 24th of April, Chair, after another hearing, so that we pursue the settlement process. So the dismissal, and then Ms. Chairperson jumps in. Sorry, Chair, I'm confused. Then you have to explain to me, why are we settling if we're going to win this case? And what do you say, Mr. Mkwanazi?
It looks like I said, we don't know.
Yes. Well,
Did you mean you didn't know why you were settling?
I don't remember.
Yeah?
I don't remember saying that, but yes, this was taped.
So you must have said so.
I must have said so, yeah.
And in the context, it could only mean you didn't know why you were settling. Is that right? In the context. Because the question which had just been asked.
I knew what we were trying to settle. The issue was, there was a contention on the sanction. So we were dealing with the sanction. So yes, I knew that. Yeah.
Yes, but I'm saying, in the context of this discussion, if the recording is correct that you said we don't know, could it...
Chairman, I don't recall why I could have said that, yeah.
Yes. Okay, all right.
well, Mr. Mkwanazi, is it not perhaps that you were caught off guard? I mean, what you couldn't tell your fellow directors here is why you were settling. Isn't it because you didn't want to tell them, I'm doing this because I've been told to by the minister? You couldn't tell them that. So you literally were gobsmacked. You didn't know what to say. Because here, your legal man had said, we're going to win this case. And in fact, he appears to have said, well, that's why we postponed, because we don't want that.
Well, I don't know, Mr. Myberg, whether you want to take him step by step. I think all of the points you are making are important, but you have got all of them together.
Fair enough. It's also late in the day, I do apologize. Mr. Mkwanazi, I mean, you were caught here, weren't you? Because Mr. Mpoma, the person who you had brought in to deal with this, had now told your fellow board members, you're actually going to win this case. It put you in a bit of an awkward position, didn't it? Because, of course, you had already negotiated.
That is correct.
Yes, so you were in an awkward position, right?
Not true.
And you were literally gobsmacked. You didn't know what to say. You were caught off guard, correct?
I would agree with you.
Yes, well, absolutely. And then what's insidious, I put to you, is look how you change so quickly after you give it thought. Doris Chairperson says, you say, we don't know why we're settling. Chairperson says, but Sachs says we stand a very good chance of winning. And all of a sudden you say, no, it's 50-50. I mean, really, Mr. Mkwanazi. I mean, honestly, it must be embarrassing to see this.
Don't forget, my saying 50-50 comes from a Dennis Reed's opinion, which we had seen. I'm not sure of the timing. Yeah. I'm not sure of the dates as well. Yeah.
But that's really not my point. You went from, I don't know, to 50-50 within a sentence.
Which means, Mr. Mkwanazi, you were saying the strength of your case and the strength of Mr. Gama's case was more or less the same. And yet, Mr. Mapoma, a senior legal person within Transnet, had just finished saying, we have a very, very strong case. And he's a lawyer.
Yes, he is.
Yes. And then Mr. Pearce says, then I don't understand why we are settling. Then you say, we don't know. Then he says, but Sachs says we stand a very good chance of winning. Then you say it's 50-50. So 50-50 is contrary to what Mr. Mapoma is saying.
I agree, Chairman.
Yes.
See, Mr. Mkwanazi, you had a different agenda here because settlement wasn't rational. It certainly wasn't rational in relation to your prospects of success. You had a different agenda, didn't you?
Not really.
I see. Now, what really shows up the board is the next paragraph.
Well, maybe before that, Mr. Mybeck, just in the paragraph, Mr. Mkwanazi, that Mr. Mybeck read to you where Mr. Mapoma is saying that Transnet has got a very, very good case against Mr. Gama. What do you say about this statement by him, where he says, after saying how strong Transnet case is, he says, that is why we said, let us rather postpone to the 24th April, Chair, after another hearing, so that we pursue the settlement process. What do you say, what's your comment about that statement?
It sounds like a contradiction, Chairman, because although he does indicate that we have a good case, he then say, let's rather postpone. It sounds like a contradiction.
Because when you have a good case, you don't want to postpone, you want to finalize the case. You are ready.
I agree. Yeah. It's a contradiction.
I'm leaving it to you, Mr. Mybeck, yes, to say the next point.
Well, it's a contradiction unless you know what was happening. And the last thing you wanted to do was to go to arbitration and win, because you wanted the man not only reinstated, but you wanted to give him a shot at becoming the group chief executive. And when you see it that way, it's not a contradiction at all.
But that's not my statement. That is Siyabulela Mapoma's Yes. He's been quoted. Yes.
But you see, Mr. Mkwanazi, he knew what you were up to. He knew the game because you had told him. Right at the outset, you had told him. And that was his mindset. He knew what you were doing.
Okay.
He knew that you told him that you had been instructed by someone above the ministry to reinstate Mr. Gama.
And therefore, winning the case at the arbitration would defeat the whole object of Mr. Gama being reinstated as you had been instructed according to Mr. Mapoma. Therefore, it had to be postponed to try and settle, because otherwise we are going to win this case and Mr. Gama won't come back. What do you say?
I understand, Chairman.
You understand?
No, your logic, Chairman, makes a lot. It's logical.
Yes. Okay.
But Mr. Mkwanazi, you're very good at sidelining issues. I mean, the point is, the importance is not that it's logical. The importance is that it's also true. Correct.
Also, funny enough, I still don't understand what Mr. Mapoma was saying with this sentence.
Well, let me
I truly don't understand.
What I understand Mr. Mapoma to be saying is that you couldn't go to arbitration because Mr. Todd and his senior counsel was going to win that. And that then would have thwarted the plan to get Mr. Gama reinstated and also to allow him to have a shot at becoming the group chief executive. That's what he's saying, in effect.
No, I understand what you're saying.
Right. And not only is it logical, but it's also true, because you had been instructed to reinstate Mr. Gama. Correct?
Reinstate is a strong word.
Choose another word.
I've been instructed to look into the fairness stroke unfairness of particularly the sanction.
Correct.
Yes.
And here your chief legal advisor was telling you that you've got a very, very good case. In other words, that the sanction is fair. So you had looked into it together with him, and there's his conclusion. Right? So where to from here?
Advocate, I'm not sure what you want me to say.
Let me take you to the next paragraph. You've said, so Mr. Mpoma says you've got a very, very good case. Ms. Chairperson is saying, well, then I'm confused. You say, I don't know. Then you say we've got a 50-50 chance. Ms. Mnyaka then chips in by saying, I think, Chair, let's move on from legal now. Because that's the problem. I think let's move it from legal. He's given his opinion, which, by the way, I don't agree with necessarily. It's his opinion. I have an opinion. He shares an opinion. Everyone here has an opinion. Now the accountability and decision-making comes from this committee. And let's decide at this committee what we are deciding on this deviation. Straight away you say, colleagues, I will deviate from clause 4.8. Nyaka says, I'll do the same. Sharma says, I won't. You say, we'll record it. And there we go, 3 against 1. Now, this Ms. Mnyaka, is she a lawyer?
No, I don't think so.
I see. Is that how things really worked? Mr. Mkwanazi, I mean, here you have a person saying, look, we've got a very, very good case. You get a board member saying, I'm really confused. You say, I don't know what's going on. Then it's down to 50-50, and the next person says, let's just leave aside this legal advice. Let's vote in favor of deviation. That's what happened here. It's incredible.
I agree with you. Yeah.
Do you accept that upon reflection and reading this, it truly is incredible? I mean, this is the work of the Corporate Governance and Nominations Committee of Transnet, of which you were the chairperson.
That is correct.
You could only have conducted yourself, I want to put you in this way, if you had another objective. Isn't that so?
No, because still, even if we are deviated from clause 4.8.4, there was a recruitment process where this individual would have competed against a lot of other individuals.
Well,
you see, when you try and find a rational explanation for something, for some decision, and you can't find it, you are bound to look elsewhere and say, okay, there is no logical explanation, there is no sound explanation for this decision. So why would these people have done this? I mean, there are a number of things that since this morning we have asked you and you have responded, we have discussed, which it seems to me step by step make the board's decision to reinstate Mr. Gama seem very irrational. We will see by the end of your evidence whether that's where we will be or whether we will be at a point where it seems rational, it can be understood and so on. But we go back to this position. I mean, when we read the statement by Mr. Mapoma here at page 855, where he tells the committee how strong Transnet's case is, how good the chances are that Transnet is going to win this arbitration. And then he says, that is why we said, let us rather postpone the matter to the 24th of April so that we can pursue a settlement process. Obviously, that means, as far as he knows, to say the least, he thinks winning this case is not a good idea. Because otherwise, when you think you are going to win and you want a win, you are going to say, I want the arbitration tomorrow, I'm ready, you know. But now, the way he talks, it's like that would be bad news if we win. So that's why we have postponed. We want to try and settle the matter. And then you go back to me sitting here, who have had evidence of Ms. Hogan. I've had part of the evidence of Mr. Zuma. Ms. Hogan said to me, the board, which is the board before your board, interviewed various candidates for the position of Group Chief Executive Officer for Transnet. It was a rigorous process. They recommended, they came up with a candidate. They recommended the candidate. The candidate was Mr. Sipho Masego. And Ms. Hogan put the candidate before Mr. Zuma and said, I support this candidate. The board says this is the candidate. And she says, Mr. Zuma said, my only choice for the position of Group Executive Officer for Transnet is Mr. Gama. And she said, but Mr. Gama has not been recommended by the board. The board thinks he still needs some more experience. And in any event, Mr. Gama is facing some investigation or some allegations. There could be a disciplinary process. There are serious allegations against him. And then Ms. Hogan says, Mr. Zuma said, well, in that process, in that case, the position will have to remain unfilled until those processes have run their course. And Ms. Hogan wrote a memo or a letter to Mr. Zuma, which set out exactly what the process had been. But the position remained unfilled until, of course, your board came in. But Ms. Hogan gets dropped from cabinet at the end of October. This is at a time when those processes that Mr. Zuma had spoken to Ms. Hogan about, if Ms. Hogan's evidence is true, had run its course. Mr. Gama had been found guilty and had been dismissed, but he had referred this dismissal dispute to the bargaining council. Ms. Hogan gets dismissed. Another minister gets appointed, Mr. Kigaba. And on your evidence, it looks like even before he officially starts as Minister of Public Enterprises on the 1st of November, he meets with you. But even if you are mistaken that it was in October, maybe it was early November, it looks like one of the first things he does, the new minister, on your version, is to call you and raise, among other matters, the Gama matter with you, and says Mr. Gama's dismissal was unfair. And on your evidence, he instructs you to review the Gama matter. Obviously, the review could lead to Mr. Gama being reinstated. Of course, it could lead to something else other than reinstatement, but reinstatement is one of the things that it could lead to. You agree? You see? So Mr. Kigaba, on your evidence, initiates a process in terms of which your board must relook at this case of Mr. Gama. You relook at that case, you ask for legal opinions, and most, if not all, say this dismissal was fair, but of course, Denise Reitz one has got a paragraph which says anything can happen when it comes to sanction. And then I said to you earlier on, the way you and your board were handling the matter, it appears like you were bending over backwards to accommodate Mr. Gama. You understood when I said that. And then you are now in this committee, the Governance and Nominations Committee. What are you talking about? You are talking about whether this man, who was found guilty of such serious acts of misconduct by an independent chairperson, who could not have been part of any factions within Transnet, a senior counsel, who ran what appears to have been a very thorough process, and Mr. Gama being represented by a strong legal team, including senior counsel in that process, and he was found guilty out of that process. You are now saying, in effect, look, even if we have not taken him back yet, let him run for a higher position. You have not even taken him back to his old position, but you are talking about saying, let him run for a higher position. It doesn't make sense to me unless there was really an agenda to bring Mr. Gama back. That is what, those are the thoughts that are in my mind. And I mention them to you so that if you have anything to say to me that could influence me differently, you can say so. But that's what seems to come to my mind to say, the way this committee is acting, the way this board is acting, it's like it is hell-bound, it is hell-bent to get Mr. Gama back, not only to his previous position, but they want him at the top. They want him to run for this position. Now, how do you seek to be party to the possibility of promoting to the highest executive position in the company somebody that has been found guilty of such serious acts of misconduct? How do you do that as a board? That's what I can't understand. If you are able to make me understand it, tell me.
Chair, I cannot make you to be able to understand it, but your analysis is very good.
You agree with the analysis? Or you understand it?
Yes, I fully check it.
Yes.
I understand it and I agree with it.
And you agree with it? Okay. Mr. Maybeck?
Thank you. So that's then the 3rd of February. I'd like now to take you, please, back to bundle 2.
Bundle 2. Okay, it must be that one.
Mr. Maybeck and Mr. Mkwanazi, the witness, and Mr. Mkwanazi, the lawyer, we are at about 5:15. Let's talk about how far we can go. I can still go on up to 6. If everybody is happy that we do that, I'm happy to do that. And then maybe at 6 we can, if we haven't finished, we can talk about the way forward at that stage. Are you happy to go up to that?
Yes, certainly.
Point?
From my side.
From your side.
Obviously.
Mr. Mkwanazi, the lawyer, what is your situation?
We're willing to proceed.
You are fine with that? Okay, all right. Thank you. Okay, all right. Thank you. Let's continue then. What page of what bundle?
Bundle 2. I want to go to page 6, please. Mr. Mkwanazi.
Page 6.
Yeah.
Wait. Page 6. Okay.
This is a draft settlement agreement. If you go to page 10, you'll see it was actually signed by Mr. Gama on the 10th of February. There were a couple of minor...
I see that.
A couple of minor amendments were made when it was subsequently signed. But the point is that it was signed before the board meeting on the 16th of February, correct?
That is correct.
I'm sorry, Mr. Maybeck. Please don't forget your point that you want to ask. I just want to mention one thing arising from what I said to Mr. Mkwanazi. You see, Mr. Mkwanazi, going back to what I said last time, I said Mr. Zuma has denied Ms. Hogan's version that he said his only choice for the position of Group CEO is Mr. Gama. I don't know what finding I will make in the end, but if Ms. Hogan's version is true, then it seems that there may be room for somebody to say Mr. Zuma would have been quite disappointed in the fact that Mr. Gama was dismissed and had been dismissed because that ruled him out of the running for the position of Group CEO. And it may well be that the new minister had a discussion with him, and he might have mentioned that there was this issue of Mr. Gama, and he needs to look into it. He might not have said he should be reinstated, but he might have said he should look into it, and maybe that is why he instructed you to review it. You understand that, but I'm not saying that is so. But I'm looking simply at the various versions and looking at what was happening and trying to make sense of what seems to have been happening. Thank you, Mr. Mybeck.
Yes, thank you. So the point I was making is that this agreement is signed by Mr. Gama on the 10th of February. Now you need, of course, some legal advice to sell this to the board. So it's to that legal advice that I want to turn now, please. Could you go to page 12? And you would have seen these documents. On Monday, the 14th of February, so the board meeting was on the 16th. Mr. Mpoma sends to Sabu Gule this email. Sabu, the chair has asked that we prepare a 2-pager for him for the board meeting. I've started the process. Please look at the attachment and finalize / settle. You accept that you asked for this 2-pager?
Yes, I did.
And do you also accept Mr. Mpoma's evidence that that was the 2-pager, and you can turn to page 3 earlier in this bundle. That was the advice that you sought. If you look at paragraph 4 of the consultation note, where you had said that what you were looking for was an opinion setting out that there was some unfairness towards Mr. Gama.
That is correct.
He said he was trying to find here in this memo some unfairness.
That is correct.
Well, what we do know is that Mr. Mpoma, in his 2-pager, doesn't deal with the unfairness of Mr. Gama's dismissal, does he?
Chairman, can you repeat? The sound was a little poor there.
If you have regard to Mr. Mpoma's 2-pager,
there's a problem with sound.
Let's take a short break while they are attending to the sound.
Certainly, Chair.
We adjourn.
All right.
Thank you, Chairman. They said 2-6 o'clock.
Mr. Mkwanazi, can you hear us? Lee? Hello?
Wait, I can hear you.
Yes. Can you hear the hearing venue? Can you hear us now?
Yes, I can hear you. It's clearer now.
It's clearer now. Okay, it's fine. We'll come back. Thank you so much. Thank you.
Okay. Okay. I'm checking if, no,
We are waiting for the judge, Mr. Mkwanazi. We'll let you know when you're coming in.
We will be starting soon, Mr. Mkwanazi. We are going to be starting soon.
yeah. Okay.
Thank you. Yes, continue, Mr. Maibek. I'm told the sound is fine now. Thank you.
Sorry, I beg your pardon. Mr. Mkwanazi, what I wanted to just explore with you is that in Mr. Mpoma's two-pager, nowhere does he say that Mr. Garba's dismissal was unfair.
I don't think he says that.
Yes. All right. And
Yeah.
then I'd like to take you, please, to paragraph 7 of his two-pager, page 13.
Page 18. Okay. I'm there.
So it says the current Transnet board commenced its duties on 13 December. The chairman of the board, with the support of the shareholder minister, has within his rights and obligations decided to revisit the matter of the disciplinary proceedings against Mr. Gama. This decision was informed by a number of reasons. And then ultimately those reasons lead to the solution being a proposed settlement, and we know that the proposed settlement was reinstatement. Correct?
What page is that? Bundle 2, page 13.
Yes.
Paragraph
Oh,
7.
at the bottom there. Yes.
Yes.
Okay, I see it. I see it. Thank you.
But the point is that the decision to revisit the disciplinary proceedings was done not to review or to look at, but to revisit, was done with the support of the shareholder minister. Is that right?
That is correct.
And then what Mr. Mpoma does is he lists a whole lot of things. There was a public protector complaint. 9, there's risk of litigation. 10, the judicial process, he says, is extremely slow. 11, there have been acting appointments. 12, acting appointments. Good corporate governance related to acting appointments. Mr. Gama is a highly experienced executive. And 15, we continue to incur legal costs. Nowhere does he say this dismissal is unfair, does he?
He doesn't, yes.
Yeah. Were you surprised? Or are you surprised?
No, I'm not surprised.
All right.
Yes.
Okay. So now, this wasn't the 2-pager you were looking for, correct?
That is correct.
Yes. So he passes it on. Someone then had to fill in the gaps. So he passes this on to Denise Rates, we know, all right? And
Yes.
then at page 13, they were asked to settle or finalize it. And the next day, Mr. Sangoni
Yes.
says, "Dear all, please herewith the document which Mr. Mpoma sent us yesterday with our amendments." Now, the only difference between Mr. Mpoma's 2-pager and Denise Rates' now 2.5-pager are the additions of new paragraphs 10 and 11, which you find at page 17. Would you agree with that?
Yes.
Okay.
I agree.
So this is what they say. At 10, in the arbitration before the Bargaining Council, Mr. Gama has challenged the appropriateness of the sanction of dismissal. The issue of sanction is a very complex and perplexed matter to which there is no clear and straightforward answer. This is demonstrated by, amongst other cases, the celebrated case of Sedumo versus Rustenburg Platinum Mines, in which the Labour Courts and the Constitutional Court on the one hand, Supreme Court of Appeals on the other, came to a different conclusion on sanction. The other cases dealing with the issue of sanction, which also demonstrate the complexity of consideration of appropriate sanction, are the Shoprite Checkers cases, in which the facts in the 2 separate cases were similar, but the Labour Appeal Court in each case came to a different conclusion. In one case, the finding of the Labour Appeal Court was endorsed by the Supreme Court of Appeal. Well, that's not particularly helpful by itself, is it? It's just what you might find in a textbook. It says, well, reasonable people may notionally have different views of sanction given a particular set of facts, correct? But it doesn't say anything in relation to Gama's case, correct?
No, it doesn't.
Yeah. So then we're down to one single paragraph. And it comprises of 2 sentences. It is accordingly our view, now I don't know where the accordingly comes from, because I can't see how it can follow from 10, but it's accordingly our view that there is a probability that the Bargaining Council or a court, considering the appropriateness of the sanction of dismissal of Gama, may reach the conclusion that dismissal was not appropriate, having regard to the challenge on sanction advanced by him. In that instance, the court may either award compensation to Mr. Gama or find that a lesser sanction ought to have been imposed and therefore order reinstatement. There's no definitive advice there at all, is there? They say, well, X may happen or Y may happen, correct?
It creates doubt, yes.
Yeah, so, but that's the point. And you landed up opting for an opinion of 2 sentences, really, that at most creates doubt, and you opted to follow that opinion instead of the 25-page opinion of Mr. Todd. Understandably. Correct?
That is correct.
Yes. So at most, all this does is create doubt, but it doesn't tell you why. It doesn't say why.
That is correct.
Mr. Mkwanazi, it is extraordinary. Are you going to advance before this commission that you legitimately and honestly settled Mr. Gama's case because you thought you had poor prospects of success at arbitration. Surely you cannot advance that proposition. On the strength of this two-sentence opinion, in inverted commas. Mr. Mkwanazi?
Yeah, no, I'm there. And also, don't forget, it continues to indicate paragraph 12, 13, etc.
None
in
of that-
terms of
sorry.
the need to come to some
No,
conclusion.
but none of that has any bearing on prospects of success. What you were looking for was an opinion that shows some unfairness so that you could persuade your board members to agree to the reinstatement of Mr. Gama at the board meeting of the 16th of February. You yourself said that. This is the best that
true.
could be done. It doesn't show unfairness, it shows some doubt, correct? That's all.
That is correct. That is correct.
So,
Mr. Maybeck?
Mr.
Okay,
Chair.
all right. You get this opinion being expressed in this paragraph. It is, it doesn't say, well, when you look at it, sometimes it's difficult to say what it does say and what it doesn't say. But on the one hand, it says there is a probability that the bargaining council or court, considering the appropriateness of the sanction of dismissal of Mr. Gama, may reach the conclusion that dismissal was not appropriate. But it doesn't tell you why there was a probability. It's just an unsubstantiated statement. There was a probability, but it doesn't say what is the basis for the view that there was a probability. It doesn't tell you that.
No, it doesn't, yes.
And then, of course, it says that there's a probability that the bargaining council or a court, considering the appropriateness of the sanction of dismissal of Mr. Gama, may reach the conclusion that dismissal was not appropriate. It doesn't even begin to say, here are some of the things which, if the bargaining council or a court were to go that route, that it would base its view on. It doesn't even begin to say that. You accept that?
I accept that, Chairman.
So one then is bound to say, why would somebody of your experience, because you were quite experienced, you had even been group executive of this entity yourself many years previously, you experienced in corporate matters, you experienced in dealing with issues. I'm sure you would have dealt with lots of dismissal matters at one stage or another as executive or group executive. Why would you prefer this opinion as the opinion on which you would base your decision to reinstate Mr. Gama, as opposed to, one, the opinion given by Mr. Todd? You would have heard when he gave evidence here. He is a specialist labor lawyer. Of course, I think Dennis rates also are specialists. But he gave an opinion that you read and you see as reflecting quite an application of mind on various issues. You agree?
Agree.
Yes. And you were also aware of the opinion from Weber Wenzel, which said the process was fair.
I'm aware of that.
You were aware that the chairperson of the disciplinary inquiry, who came to the conclusion that Mr. Gama's the sanction of dismissal was a fair one, was a senior counsel, a labor lawyer himself. You were aware of all of that. So the question that Mr. Maibek was asking is, how does one explain your reliance on this questionable opinion, which is not motivated in any way, when you have these other, certainly looking at Mr. Todd's one, because that one is here, I've read it. It's, it shows somebody who has applied his mind to all the issues. And of course, he had the benefit that he had been handling this matter for about 2 years or so. So why would you prefer this one?
Chairman, as I indicated much earlier, a different set of eyes we felt was needed. I tend to agree with you that this was a weak submission, and I think we gave Mapoma that feedback as well, and which is why then they tried to augment it, but even the augmented one, Chairman, frankly, it's a weak submission.
But again, it's like, you know that there is this opinion which is correct, which says this dismissal was fair. But it's like you keep on wanting another one that will allow you to reinstate Mr. Gam, that will say something else. You see this one, it says there is this probability. You see it provides no reasons for this probability, provides no basis, but nothing says to your mind, look, let's go back to that opinion, which we can't fault. Mr. Todd's one. We can't fault, because as I understand it, you have not been able to say we had a problem with that opinion, isn't it?
No.
You could not fault it.
No, I couldn't fault it.
Yes. So one asked the question, why didn't you and the board act on the basis of this opinion from Mr. Todd that you could not fault?
Chairman, as I've indicated, we needed a set of different eyes, because true, had we asked Mr. Todd, my interpretation is he had an opinion already, and because we wanted a different set of eyes, we then asked Dennis Rates, and yes, it's not a detailed opinion, but it created some doubt as to when we go to the bargaining council process of whether we will win or not. Yeah, it did that.
But the difficulty is that you yourself have indicated this opinion was weak.
Yes, I have
indicated it was weak. You have accepted that it was not motivated. It didn't provide a basis, or it didn't show you this is the basis for on which it is grounded, And I would have thought that if you and the board, in seeking to get somebody else's opinion other than the opinions that you had already got, which were saying the dismissal was fair, I would have thought that if you remained open-minded as to whether you would reinstate or you would settle or not settle, I would have thought that when you got this opinion, you realized that it was weak compared to this other opinion from Bowman Gilfillan, and you saw that it was not even motivated. I would have thought that you would say, look, if we act on the basis of this opinion, we are opening ourselves to serious attack. The opinion that is that we should act on is this one that we can't fault. That is what I would have expected. You would go along that would be a reasonable thing to do.
I agree, Chairman.
Yes, but the board didn't do this.
The board went with this opinion, yes.
Yes, okay, Mr.
And even the augmented opinion was still weak.
Yes, but of course, surely sitting here now, looking at this, you would accept, would you not, that you ought to have acted in terms of the opinion given by Mr. Todd?
Chairman, maybe not, because as a new board coming in, you needed a different set of eyes on this issue, particularly on the issue of sanction. Yeah, and that is all that the board was looking at.
No, but I'm not sure that I understand that. You see, when you put it like that, it gives the impression that you wanted a different set of eyes, so to speak, and you were going to take what they say, what those lawyers say, take their view without evaluating it yourself and seeing whether it was sound. Whereas if the approach was, we want to hear what they have to say, but we are not going to, we will only act, we will evaluate both opinions if they are not the same. We'll evaluate both and we will act on what we believe is sound. That's what I would have expected. I shouldn't have expected that of the board.
Chairman, I agree with your analysis. We did not take the two opinions and put them side by side and debate them side by side.
Yes.
We did not. We debated this one.
Well, I guess, and decided to go along with it, even though you realize it was weak and it was not reasoned.
Yes, Chairman.
Yes. Okay, Mr. Maybeck.
Yeah, thank you. All right, well, so now we know that this is weak. I just wanted to find out from you, what did you do with this weak opinion? Did it serve before the board? Because that's not something that's clear to me.
If I recall, it would have served in the corporate governance committee.
No, there's no corporate governance committee before the 16th. You prepared this for the meeting of the 16th. Did this serve before the board on the 16th?
There was a meeting on the... Wait, there were two meetings on the 16th. There was a meeting, a very short meeting. It could have been a corporate governance just before the board to consider this report.
Did this opinion serve before the board on the 16th?
On the 16th.
Remember,
that is correct.
Your objective, you told your attorneys on the 22nd of January, is that you need some friendly advice so that you can persuade the board to reinstate Mr. Garner at the meeting of the 16th of February. Did you present this did you present this 2.5-pager to the board at the meeting of the 16th of February?
Chairman, I think I did,
right.
or even at a COP-Gov meeting just before the board.
You think you did?
Yes. I will have to follow the audit trail.
But this is very important, Mr. Mkwanazi, because we need to know, was it on the strength of this opinion, and I'm loath to call it that, because the advice is 2 sentences and it's unreasoned. Did the board decide...
On the advice of this opinion, yes.
Just bear with me, because this is it. So the board decided to reinstate Mr. Gama on the strength of this opinion. Is that right?
That is correct, yes.
So was this ever then put onto... I haven't seen it in its final form. Was it put onto the Transnet letterhead, or... I mean, you can tell us, what did you do with this? Because Mr. Mpoma said he's... Sorry, if you bear with me. Mr. Mpoma said he sent it to you.
Yes, it was tabled. I don't recall in what form, but it was tabled.
Yes, but was it tabled as a Transnet opinion, your opinion? Was it tabled as a Denise Rates opinion? In what form was it tabled?
I'm not sure now. I'll have to ask Mr. Mpoma myself, or try and look at the audit trail of the documents.
Bearing in mind, Mr. Mpoma was not at the board meeting. Mr. Mpoma's evidence is that he gave it to you. So what did you do with it?
It was tabled.
Okay. And you've said...
I'm not sure in what form, whether as a Dennis Rates opinion or as an email from Mr. Mpoma, but it was tabled.
But you see, that makes it so much worse. Are you suggesting that the committee may have decided this matter on the strength of this advice, which wasn't even provided on Denise Rates' letter?
That is correct. That is correct.
So you present this opinion to the board, and I'm sorry I'm pressing you on this, but whose advice did you present it as?
I would have presented it as advice through group legal, but I was aware that it came through Dennis Rates.
So you presented it as the advice of group legal?
Yes, who had consulted Dennis Rates.
It was only a few days before that Mr. Mpoma had told some of those very directors, the self-same directors, that you had a very, very good case. I mean, this is a joke,
that is
Mr.
correct.
Mkwanazi, isn't it really? I mean, honestly.
Hey, Mr. Mkwanazi.
Mr. Mkwanazi, this is not legitimate, is it? I mean, I don't know why you don't just accept that you had another agenda.
No, this is what was presented to the board.
Sorry?
This is exactly what was presented to the board, Mr. Mapoma's submission.
Do you accept, Mr. Mkwanazi, at least now, you know, we have been dealing with this from the morning, but you were listening to Mr. Todd's evidence yesterday, I mean, the questioning, you followed it, and maybe you listened to Mr. Mapoma's evidence as well. At least as you sit there now, do you accept that the board's decision and your decision to reinstate Mr. Gama in these circumstances doesn't make sense?
Chairman, we appointed Dennis Reeds and to look into certain aspects of the sanction in terms of the Transnet bargaining council processes. And this is the opinion they came up with. I had a consultation with them, and yes, this is the opinion they came up with. And I used that opinion even at board, and I suspect even at the COPGAV. I agree with you that the opinion compared to the opinion of Mr. Todd is weak. I fully agree with you. And which is why then we requested that there must be a follow-up submission based on the same opinion, which came in something that is dated 22nd February 2011. But it's basically the same opinion.
You must be talking about Denise Rates' report or letter. dated 22 February 2011 at
It's
page
trying to
19.
supplement what they'd given to Mr. Mako.
Go to page 19 of the same bundle.
Yes, I'm on page 19.
You see, that is a report, says report for Transnet on settlement. It's
That is correct.
on Denise Ray's letterhead, and it's dated
That is
22 February, and it goes up to page 22. Is that the document that you say augmented these two?
After the board meeting, yes,
After the board meeting.
that is correct.
Okay, so before the board meeting, the augmentation was not there.
It was not there. Yes, Chairman.
But you see now, it seems to me that you and your board were so hell-bent on reinstating Mr. Gama that when you had the other document that had this opinion saying there is a probability that the bargaining council or a court considering the appropriateness of a sanction of dismissal of Mr. Gama may reach the conclusion that dismissal was not appropriate, that when you had an opinion, this opinion, which was, in your view, giving you some leeway to settling the matter and getting Mr. Gama back, but you realized that it was weak, you thought, no, there needs to be augmentation of this opinion, but we will make the decision to reinstate him, Mr. Gama. The augmentation can come back, that can be done later. Is that right?
That is correct, Chair.
Yeah, okay.
And then, of course, the augmentation really makes your case worse and not better. And let me show you why. So if you go to page 19, this is where you find the augmented opinion, 22 February.
Yes.
What page, Mr.?
Page 19 of bundle 2.
19.
So the first 1.5 pages just sets out what happened during the negotiations.
Okay.
Then have a look at and read into the record, please, paragraph 1.1.
Paragraph.
This is now the augmented and improved opinion. Please read that paragraph.
I must read that paragraph.
Yes, please. Into the record.
There are various opinions which have been obtained from reputable firms of attorneys with regard to the prospects of success of Mr. Gama in successfully challenging his dismissal by the company. All the opinions, including ours, which we gave after perusing documents pertaining to the disciplinary inquiry, were of the view that Mr. Gama's chances of successfully challenging his dismissal are not good.
So here you told.
I've read it.
Yeah, well, that's what I'm saying. It makes your case so much worse. Because in the augmented opinion, now Denise rates tell you about opinions from reputable firms, all of which have come to the conclusion that Mr. Gama's prospects of success are not good.
Effectively saying Mr. Gama has no case.
But that still you carried on.
How do you settle? How do you reinstate him? How do you give him full back pay? Of course, how do you even undertake to pay his legal costs? It's just something that is so difficult to understand, Mr. Mkwanazi, except if one says there was some other agenda that the board was pursuing in wanting to get Mr. Gama back. It was not the question of was there some unfairness in his dismissal. It was not just a question of are we likely to lose the case in the arbitration. It was other considerations. Can you understand why, what I'm saying?
I understand what you're saying, Chairman.
Can you fault it?
I can't fault it, Chairman.
Yes.
And
Mr.
then,
Maibach.
Mr. Mkwanazi, just to finish on this, if you go to page 21, you say this was an attempt to augment. But under the heading of
correct.
sanction, that's precisely the same paragraph that paragraph there is paragraph 10.
That is
And
correct.
the last paragraph was paragraph 11. So there's no improvement.
Yes.
It seems that the Nasrates weren't able to improve their advice.
No, there's no improvement.
But you know why?
I agree, there's no improvement. It's the same.
But it couldn't be improved upon because it seems that they were not of the mind that the dismissal was unfair. In fact, there's a massive contradiction, isn't there, between what you find in 1.1
There is.
and what you find in 4.
That is correct.
But despite that, you pushed on.
That is correct, Chairman.
Mr. Chairperson, I see that it is now 6 o'clock.
Yes. How much more time do we still need?
I think I still need quite a bit
Quite
of
some time.
because I have yet to go to the essence really of Mr. Todd's evidence, and that is that
Yes.
none of these 3 charges were things that were really capable of being condoned.
Yes.
And in order to pursue that examination, I'd obviously need to analyze the findings of the chairperson and then go and deal with that. So
Yes.
if Mr. Mkwanazi can come back on Monday.
Well, let me first check from yourself. From your side, are you still able to maybe add another hour or another 30 minutes, or you have been standing the whole day? I must think about that.
It's becoming increasingly difficult, Mr. Chairman, I must be honest.
Okay, no, that's fine. So you would suggest that if possible he comes back on Monday?
Yes.
Okay, all right. Maybe we could start early.
That would be
Yes.
ideal.
Mr. Mkwanazi, the attorney, and Mr. Mkwanazi, the witness, it seems that we should adjourn now. I know that I think we are all seated except Mr. Maibach. He's the only one who has been standing the whole day. We need to think about that. But he suggests that we could continue on Monday morning. Would that be fine with you? Let's start with the lawyer.
Obviously, we haven't consulted on this. I wonder, Chair, if perhaps you could give us a 5-minute break just to verify if our hands are aligned, Chair.
Okay. Mr. Mkwanazi, the witness, you are fine. You would be fine with that.
I think I'm available, Chairman. Yes.
Yes. Okay. All right. Okay.
Chair, can I suggest the reason I wanted to consult was actually with Mr. Mkwanazi himself. But if it's available, Chair, we'll by all means avail ourselves because it's also in our interest to achieve the process to fast track. So let's commit ourselves and check what we're doing on Monday morning.
Yeah, I don't know why there is always difficulty in hearing you. The line or reception is bad, but you still require, you are still asking for a 5 minutes break, or you say
no, Chair.
It's
no,
fine.
Chair. We are confirming.
Oh, you are confirming. Okay. Okay, all right. Shall we?
The suggestion we want to add here is that we would require additional information from the Commission, particularly related to the bundles. So if that can be arranged, we'll be very grateful for that. Thank you.
Okay, shall we start at 9 on Monday? Is that fine?
Yes, certainly,
Okay.
Chairperson.
Okay, all right. We are going to adjourn then, and then we will continue on Monday at 9 o'clock. We adjourn.
Thank you, sir.
All right.
Yeah.